We're going to get started now. We have Cody. Cody's available now to talk to us. And who would like to give the opening prayer? Anybody here want to give the prayer? Steve, you want to do it, the prayer? Okay.
Thank you, Father God. We are gathered here as a divine appointment that you have set up. We have minds that are seeking truth and hearts that love freedom, that we try to emulate your glory upon this earth. I ask that you anoint our minds to receive the truth and to receive the message of freedom, and we expound it among others. In the name of Jesus, amen.
He's got a 2-hour window. Okay, Cody, thank you again for coming and visiting with us on Zoom.
Absolutely.
And, you know, we talked to around 3 o'clock, which is Central Time. So talk as long as you want to. The floor is yours, and we're all ears. So, again, thank you for coming and talking to us. Cover whatever topic you want to.
Okay. Well, I've got a pretty specific subject that's been something I've been looking for a while. And I needed some personal firsthand experience in the courts before I could, know how to craft the remedy that I'm going to attempt to use. I've been on here before speaking about nuanced things, concerning the Uniform Commercial Code and the debtor, the ens legis, but I'm in a couple of battles right now about discharging debt and challenging a mortgage. Excuse me. And then there's also a dispute with a local maintenance shop about some unethical business practices that I was subject to. And in all of these battles, I've utilized the affidavit process, which so far the courts are showing me that they're ignorant of that jurisdiction and that process. And so the solution that I've come up with is that it's all fraud and it's all trickery and nonsense. And the effectiveness that I've gotten from tying the administrator of the court themselves to the Constitution is a little piece of, it's not trickery, but it's definitely
connection. We think Ian
Constitution really study it and start reading the Supreme Court case precedent from the Civil War that concern the interpretation of specifically like Article 1, Section 10 about lawful money, the unlimited ability to contract, and how that translates to being able to create entities ourselves without the state to enter commerce. I started to develop an actual series of events, if you will, to actually get there. And the way to do that is through a trust. And so whether or not I end up being successful in these battles that I'm at in the local venue, right off the bat, I'm actually planning on having to appeal it. But the supremacy clause of the Constitution and being able to put into a trust indenture the things that have allowed me to survive as long as I have in their venue, I truly believe that that is an access to remedy for anybody that wants to sign up for that trust. So I'm going to be organizing it as a public charitable trust, and its sole purpose, it's going to be revocable, and its sole purpose is going to be to stand on the flow of authority that's defined in the freedom documents about we the people being sovereign, and of course cite Supreme Court's Cape precedent for that in the indenture, and then go on to utilize the same language that I've used to really get results here locally. And the results that I'm speaking of are not concrete yet, but anybody that's dealt with the courts understands that they are underhanded and tricky. And when you box them in and they realize they've lost, they'll find a way just to throw it out and just leave you alone. And when you define being left alone as the victory, that's the mode of how, okay, we won. They're not bothering us anymore. That really goes a lot in line with both the biblical teachings of how to conduct yourself in this quest that we're all in. And so I'm real happy with that being the definition of victory. And so that's going to be codified into the trust as well. And the reason why it's going to be revocable is because when individuals who are having trouble with traffic tickets and taxes and foreclosures and all this other nonsense that they subject us to, which is just ludicrous considering how the system really works or how it's supposed to work. The definition of victory being, oh, they stopped the foreclosure, or, oh, they dropped the case, and they're not pulling me over anymore for my private plates. And the real world difference that an individual can observe after joining this trust that I'm going to set up and then using that status, standing, and jurisdiction to challenge the authority of the local courts and the policy enforcers to even talk to you without a lawful warrant. Otherwise, they're in breach of their oath of office. It really seems to me like, the way the thing that I've been looking for to contribute to this freedom movement. And so with that real world observational proof right in front of you, if you choose to join this association that I'm starting, what that'll end up doing is it'll supply validity that you can then point to in your own life with people around you and say, no, actually, really, this works. And here's how it works. And what that'll end up doing is it'll be proof to not only all the freedom movements all over the country in their various forms and iterations. Like, I can think of a half a dozen organizations right now that are all along the same tack, but everybody's kind of got their own personalized view of how to move forward through it. And the unfortunate part, in my opinion, of all of those other freedom movements, whether they be tactical civics or whether they be, the David Straight theory or Christopher Hauser or Brandon Joe Williams, they're all lacking, in my opinion, the comprehension that every single court in existence is all just an administrative tribunal of the corporation. We don't even need to be there. We are there by our own agreements that they have the authority over us. And so that's what this trust will be challenging. And, as far as standing and so the reason why it's in a trust is because then anyone who's interested can benefit from the precedent and the knowledge that I've gained and use that in a way to actually supply case numbers and reference under oath testimony. And so that kind of a availability of evidence is exactly what it is. It's evidence that the courts cannot ignore. And the vector through which we make them do that is their oath of office, and they're personally liable under multiple criminal and they're liable for treason if they don't listen to it. So it's I need a little bit more proof of concept in the battles that I'm in, but that's going to happen very soon, and I'll be able to share that with everybody as a proof of concept when it happens. But this is truly the way out as I see it, and generally in talks like this is where you get the pitch for the merchandise or the subscription fee, and or for just this and come to our meetings but that's not how I'm doing this. I'm going to be personally available to get it started to anybody that wants. Like Steve, you're probably policy enforcers. But I'm not going to charge anything. Like, this is, the Republic has already been won and bled for and bought and paid for. And the reason why I know that's the case is because the federal government wouldn't exist without it. That's the flow of power. And that's the standing that we utilize in this, is from we the people, the sovereign, as a body politic. And so right now I'm standing on affidavits to access that status and jurisdiction that are standing unrebutted. But there is a challenge that the courts could pose, is that one individual doesn't make up an association of we the people, and that's true. And so that's where the trust comes in. And then all of a sudden we have a recognizable entity that is on the same standing as the federal government, because through the Declaration of Independence, the Bill of Rights, which is basically the First Amendment, the codicil to the Constitution. And if you view the Constitution as a trust arrangement, which I do, which is the founding fathers of the grantors, and the posterity that they refer to in the Declaration is are the beneficiaries, and then the trustees are the public servants. Well, what we're doing is we're using a cause of action as breach of that contract as a standing to usurp the trusteeship. And so the trusteeship of this trust will be available to public servants if they adhere to the contract, which is the Bill of Rights. And, freedom of speech, must be presented by an indictment or presentment with a grand jury before you can be tried for anything. Otherwise, infamous crime, right? And the definitions of that are in Black's Law Dictionary and precedent of what an infamous or otherwise, capital crime is. There's all kinds of things that these Article 1 administrative tribunal courts are doing. And the thing about it is that they definitely have status, standing, and jurisdiction, these Article 1 courts. It's defined in the Constitution. But the problem is that the fraud is that they're tricking us all into believing that we're corporations and we have to be there. And we don't. And so the trust is going to identify that as well through settlement of all the accounts on your behalf with any issue that you have. And so that will essentially be the same as, quote unquote, like David Straight used to say, claiming the minor estate. But the one provision that I am putting into this trust is that, if your interest is in Federal Reserve notes, then this is not for you. That's just a debt script. The old song, I owe my soul to the company store. There's a trap there in the minor estate where if you look at it only to monetize it into currency of their slave script, then that's a trap in itself. And so the prize will be freedom and liberty as the founding documents have defined them. And exactly as they have defined them. And so it's not like this trust is going to be to go out and run drugs and guns and open a brothel. That's not it at all. It's really going to be, crafted from the standpoint of victory being defined as being left alone. You actually have your allodial title to private property, not have to pay taxes to anyone on it through the land patent process. And so it will really be a all-encompassing association, with the bylaws being standing up the republic and teaching individuals who they are, and also operating with our government in a way where you can really, the goal is to have clean hands and stand in honor and return to lawful sound money with or without the permission of the government through a private membership association with other members. So I want churches involved, so that depending on what happens with this next handful of years in the 2030 agenda and the way things are going in other parts of the world already, we can, just like COVID, we can see it rolling out. And they're going to try it here. It's just a matter of time and how far they get. And so, it really lets the whole busy destroying themselves. Let's let them and just stop playing their game. And so that is really the goal of this organization that I want to create. And I look at it as far as administrative and other people that want to be involved is, those who have the ability have the responsibility. And I took an oath before I started this journey to uphold and defend the Constitution. So that's really the goal here. And so, the Lord will provide the resources in the ways that He's got planned. And as far as, but if your goal is to get the minor estate in order to access the Federal Reserve System, then this process is definitely not slave script. We're going back to lawful money as the Constitution defines. and we'll create the value on our own to create wealth. So that's the pitch. And anyhow, the nuts and bolts of it are still in works to a certain degree, but I could definitely answer any questions about, anybody has about how I'm going to accomplish this and what precedent I'm going to be standing on, and if there's any other precedent that anybody else knows that I should be aware of to maybe incorporate into this. But it's really going to be about lawful money, which is silver and gold, defined in Article 1, Section 10. And then the fact that FDR confiscated all the gold and all the lawful money with Executive Order 6102, which precipitated House Joint Resolution 192 of the 73rd Congress, which allows for the payment, sorry, not the payment, but the discharge of debts in dollar for any currency recognized by the United States at the time. And the cool part about that is that under UCC Article 3, we can issue promissory notes on behalf of the trust, the implied trust, which is your birth certificate number, very quickly and easily to discharge any debt that the state or the corporate government might be able to levy against that account. And so we'll just settle the matter, give them what they want, write the note, and say bye-bye, leave us alone. As long as there's not a victim, there's no crime, and that's the way that the trust will be operated to get people out of the jams that they're in with the powers that be.
Okay, Cody, I got a question for you. Would you want people to be part of the trust prior to any tickets, or if they do get a ticket, then they become part of the trust?
I think that the time at which the individual would like to sign up for benefits and claim their status as one of the grantors of the Constitution, then there's a handful of ways I think to do that, regardless of whether or not they get a ticket or not, prior or after. The catalyst, that's a good question. The catalyst for the way that I'm doing this really was a function of Steve getting in hot water, not having all of his paperwork done yet. And I just got to thinking about this going, you have to do the secret handshake in order to have access to your rights. That's not how this is supposed to work. Like, if you didn't willingly and knowingly enter into a contract with your federal, local, or state government to, be subject to their statute, code, and regulation, then it's not an enforceable contract. And that's what we're standing on as a prerequisite. And we're going to go after any prosecutor or judge on behalf of the trust, and the beneficiaries of the trust. So if for proliferating that kind of nonsense and representing themselves as Article 3 courts with standing and jurisdiction to hold one of we the people to statutory jurisdiction without their consent, I mean, that's warring against the Constitution. That's a violation of oath. And so there are some documents already that are created that wouldn't hurt to have already cured on the public record, because then they're just available right away. But here's the thing about a court proceeding. It's a commercial in nature. It's not judicial, especially in traffic and family court. And so when that happens at any time, the jurisdiction can be challenged and the validity of any contract can be challenged at any time. So it's not a requirement to sign up for the trust before you have troubles. It wouldn't hurt, because then you'd be a little bit more aware of the information in it. You could read the indenture, you could check into the sources, and just that kind of investigation really helps one's comprehension. And that would be a good thing. But it's not necessary from a legal or lawful standing, to be in the trust and protect yourself prior, because the whole basis and the standing that this whole situation that I've come up with is going to stand on is the fact that the federal government and the state government would not exist without the Constitution. That's where its authority to exist comes from. The contract is already in place, and it's our public servants that are in breach, not us, through their oaths of office. And that's where the trust comes in to be with you as a fiduciary obligation to provide the benefits of what the trust is under contract, under sacred oath and honor. And so that's the standing, that's the vector that we get individuals like myself to be able to go with you as a next friend counsel and, under the terms of that contract. And so whenever you accept the benefits, then you're under that umbrella, and the courts cannot, they're going to try, but they don't have the authority or the standing to say no.
One thing that might help too is if someone became, part of the trust, that they could have some kind of a handout that they could give whatever officer pulls them over to let them know that it's a trust situation. And that might stop any ticket that could be issued.
Now I think you're back. I lost you there for a minute. I lost you at people are going to become part of the trust.
Yeah, if people had some kind of a, maybe you locked up again. We lost him again. Okay, Cody, what if we had?
I'm still here. I can hear you.
What if we had some kind of a card that we could hand an officer when they pull us over to let them know that this is going to be handled by the trust, and they might realize, hey, this is not worthy of issuing a ticket. Something like that might be good to stop in their tracks so it didn't go any farther.
Well, absolutely. And so I think that the thing to do in that instance, because when you have an interaction with a policy enforcer, that's another thing the trust is going to do is just offer training. And, there'll be absolutely some things that we can hand out that would be exactly what you need to say to an officer in any encounter, unless you called them, but as far as letting the officer or the judge know beforehand that this is trust, this is trust business, that definitely could be something. But unfortunately, until there's some recognition, and I'm not opposed to it, but I think that the result that you're implying that might happen if the policy enforcer or the official looks at the umbrella that one of the people that they're engaging with is a part of, that organization, that association is going to need to have a reputation first, to having some teeth in their local capacity before they're going to recognize that authority. At least that's my personal experience so far, is that most of these policy enforcers, judges, prosecutors, public officials are absolutely ignorant of even what their oath of office means. In one of the cases that I have going on right now, two cases actually where this is the case, the series of events is I ended up having a pretty prestigious law firm from Anchorage that's representing the interests of a bank that I'm in a dispute with over a mortgage. They started off with 2 lawyers and were very, very aggressive about getting into court and litigating, and were basically threatening me with, oh, you don't want to get into court with us. You have no idea how to litigate this. And I just flat out told them, said, you know what, you're right, which is why I'm not going to. I'm just going to go to court and I'm going to use what I know, and you guys can do what you're going to do, but I got nothing left to lose. It ain't already on the line. But you guys pushed me way too far. Never underestimate the resolve of a desperate man, ever. Because I flat out told them that. And so now they've got 5 lawyers on the case, and we're about 3 months past the point where they could have foreclosed under the premise and the legality of what they were claiming in the first communications that we had, that the challenge that I faced didn't have any legal standing, and I'm an idiot and I'm going to get in trouble. And I was like, yeah, well, probably. Let's see what happens. I just went, all right, sure, maybe. I'm not, bring it. Let's dance. And so now they've got 5 lawyers, and they're trying so hard to get the whole thing thrown out because I filed for declaratory injunctive relief against their foreclosure proceedings, which didn't exist yet, in order to create a case in reference that I wanted the dispute adjudicated. And then if I lost, then I would make them whole to the best of my ability and pay all the back fees and all the back payments if they could prove that it was an enforceable contract. Because after all, I'm here to follow the rules. I just think that they don't know what they are. And so now, instead of threatening me that, I don't know what I'm doing and they're going to eat me alive in litigation, now they're trying to get the whole thing thrown out. Like, they are going for dismissal on every ground that they can possibly try to fabricate. And their latest one was that the state of Alaska has long adjudicated that Article 1, Section 10, lawful money, is not relevant inside the state of Alaska. And so I just went, all right, if that's what you claim, prove it. And so I sent a notice to the Attorney General and the U.S. District Attorney and the prosecutor, both in their district and mine, about what their claims are, so that in case that's what happens, the judge can be subject to whatever criminal penalties need to happen in order to war against the Constitution. And so I don't think that just letting these policy enforcers know that, hey, we're a part of a trust and we're standing on constitutional rights, that means anything to them until their butt gets put on the line for violation of their own oath of office. And then you start sending them links to, I've done this on numerous occasions, and the latest one of which the Attorney General for the state of Alaska, Craig Taylor, resigned. I got a certified copy. Chapter 77, specifically treason and striking and disloyalty and piracy and under the law of nations. And man, that later that week he resigned. He was gone. And now we got a new guy to start all over with. And so, are they, maybe he was diddling his secretary and it had nothing to do with it, right? But I mean, there are no coincidences. And so what I'm getting at is that it takes the individuals, not in government service. They're going to get the memo, and they're going to get the idea eventually once they are held accountable. And it's just a matter of, not backing down before they finally get the idea. And so that's a great idea, but just don't expect it to work until after there's some interaction and some battles that where the trust itself proves to the elected officials and the policy enforcers that actually, yeah, this is a thing and we're not going to back down. And you guys need to figure out what box you're supposed to be in and live there, and we're going to get along just fine. So anyhow, just my 2 cents on that.
Anybody else? I got a question. Welcome up there.
Hey, how are you doing? Thank you for talking to us today. But I found a place where they recorded living people documents. Like a lot of the court systems, they want around DFW area won't do it, right? Because the gig is up or whatever, or people trying to record stuff on their mortgage, all this stuff, they just quit recording stuff.
Yep.
Which, I'm sure there's some kind of law somewhere, but that says they can't do that. And supposedly, if you have a napkin, you should be able to write something on a napkin and say, "Please record this," because the people's way is their soundboard, And I've gotten some fee schedules recorded, and they've had plenty of time to season at this point, in 2023, and I'm just wondering, have you had any luck as far as and how would you go about collecting on a fee schedule or credit? I mean, I call them credits. I don't that you can redeem for Federal Reserve notes. I mean, you're going to be in their system, but they operate in credits, all right? And so then you redeem those for Federal Reserve notes or whatever, or your debit card or whatever. So I know I'm playing in their sandbox at that point with any of this stuff, but it is a recorded document, and have you had any luck with any of this stuff?
Yeah, so I'm going to go ahead and frame this question in, what's your definition of victory? And so I'll go ahead and answer that with framing that answer with the definition of victory being that which I'm going to define in trust, which is, are you left alone? So the fee schedule, with the unilateral contract precedent that the government and the states and, credit card companies, you get a notice of change in terms and conditions. If you don't rebut it, silence is acquiescence to now this judgment. Well, that is something that exists only in commerce, right? Only under admiralty jurisdiction. And so in regards to the different county recorders' offices not recording your documents in regards to your fee schedules and your affidavits and that kind of thing, that absolutely is a problem. And you are right, they're not supposed to do that. But you have to understand these people are compartmentalized legal Indians. They have been doing they think that the recorder's office is only for warranty deeds and property transfers because that's what the statutes say. And they don't have the understanding that they are acting as an official of a corporation according to the bylaws of that corporation. And so, that is a battle that you could absolutely choose to fight. But, what's your time worth? And what kind of remedy is that fight going to obtain you should you be successful to get your documents recorded in one county versus another? And so my recommendation is to just find a county that'll record them. There's many around. I use Summit County in Utah right now. And Gregory Wolbach is the recorder. And man, that guy's on it. He he's accommodating. He's on, So I think that to a certain degree, you need to find who your allies are in the system itself.
I found a county in Travis, and I was able to record them there. They've been recorded since.
Well, there you go. Yeah, and so anyway, I was just addressing the part of your question there where you define that some counties don't record, and you're right, they're not supposed to do that. But once again, what is your time worth? And so,
I'm sorry. We actually recorded them doing this, not recording our stuff one time, and then walked out and asked the sheriff to come in and arrest them.
Yeah, I'm not surprised. So an arrest is different. I mean, that would be something that we'd have to, deal with for, ask for the warrant. Anyway, I won't get into the nuts and bolts, but when you're dealing with any corporation that's in the jurisdiction of government contract services, which all government agencies and corporations, municipal or otherwise, are, what you do is you have to stand on the jurisdiction. You have to define the jurisdiction in your paperwork, in your documents that you are operating in. And so that's where the trust comes in, because there's 3 jurisdictions, just like David Straight used to talk about. We've got the common law where the natural law exists, and that's where your rights exist. And then and then you've got admiralty law, which is law of contracts. And so every time you show up in a municipal corporation, what you need, and this is what the trust would do on your behalf, you need an entity of commerce in which to interact with that other commercial entity. Yes, and so the standing that we use to do this, that the trust is going to use, is that we're not going to recognize or even talk about the implied trust of the birth certificate unless they bring it up. And we're going to merely stand there as a living flesh and blood grantor to the Constitution for the United States of America. And by consequence, the initial, the individual de jure republics that give the authority to the federal government to even exist. So we're going to stand on that status, standing, and jurisdiction by affidavit of equity under the authority of trust law, by defining that you are, as one of we the people, granting the authority to regulate commerce to the federal government and the state jurisdiction government. And then we're going to prove that I was in commerce. I'm standing here like I'm not engaged in commerce. I was driving to the grocery store. I was traveling to the grocery store. And here's these affidavits that say that Federal Reserve notes are the only specie of currency because my government took everything else away from me, lawful money. So discharge. If there's any charges against the ens legis, accepted for value, discharge them as the executor of the estate. So that's what we'll be doing. And you don't really need any schedule of fees to accomplish that. Regarding the schedule of fees, I view that as a tool to put leverage on an individual in their private capacity outside of their qualified immunity, whether it be a judge or any public employee or elected official. So if that judge receives a paycheck from the state of Texas, then they need to have an oath of office on file. That's how it works. And the Clearfield Doctrine says that office is subject to the maxims of commercial contract law. So the trust already has that all cured on the public record on the beneficiary's behalf as one of the grantors and of the Constitution that creates that entity to begin with. So under the authority of the Constitution, if there's not a presentment or an indictment by a grand jury, then they're in violation. So if they would like to produce the administrative record where they've exhausted the administrative remedy process for a grievance against the trust, then bring it forward and we'll make you whole. No problem. And we're going to do that with a bill of exchange. And the trust is going to present your interest to do exactly that, to present credits and then discharge it through the Treasury to pay them and get their net retentions. We're going to give them what they want. We're going to give them, the net retention is going to go into the judge's pension. The prosecutor's going to get, they're going to get a conviction. Again, we don't care. Go ahead, write it a traffic ticket. I could care less. There's no money, so there's only discharge. So what we're going to do is we're just going to agree with them. And on paper, it'll look like they get their conviction. But because the debt is discharged, before we even walk out the door, they have no standing to hold your private property in surety to the bonds that they create to satisfy the debt, because the debt's already satisfied. So what it's going to do is it's going to give them what they want. It's going to give us what we want. And pretty soon, I would imagine that they'll probably be quite a racket of business arrangement where they're just going to make presentments like crazy for misdemeanors and traffic violations on everybody. Everybody reserve notes and we walk away. That's what I envision happening with this. And so, fees is really a tool, in my opinion, to put leverage on the individual while we're still teaching them what they're doing wrong and how they don't have the standing or the authority to haul anybody in for a traffic violation or for, a trespass against the state, whether it be criminal trespass or whatever this other nonsense that they come up with, when you go somewhere and start asking questions. And all of a sudden they come in and get the sheriff to arrest you when you're trying to record public documents. Give me a break, right? Let them arrest you. And we get their badge number, we get their name, we get their mailing address, their supervising officer. We issue them all Title 18 criminal violations with a criminal referral to the Attorney General of the state. And because we've already accepted that individual's oath of office, who said this is a violation. Unless they can produce the arrest warrant that's a result of an indictment by a grand jury, you guys are in violation. This is an emolument violation. Arrest them. Feds, come on in. U.S. Provost Marshal, there's warring against the Constitution here. You guys want to keep pushing, or you want to let them out and knock this crap off? So that's the way I see it working. And so there's definitely going to be, some individuals that come first are going to have to be put through the ringer. But in the end, we'll find out whether or not we actually have a Constitution or not. And anyway, I've got a plan for that too. It'll be in the indenture about, a writ of quo warranto. And the trust is going to put state, federal, local governments on notice of where all the beneficiaries are preemptively. The sheriff's station, the police station, we're going to notice them that any harassment of the beneficiaries, through trying to trick them into being the surety without full disclosure is going to be met with emolument violation charges. And so that's what the schedule of fees will be. And as beneficiaries of the trust, we're going to use the schedule of fees that are going to be on file on the trust, and you'll be able to claim beneficiary status to that. So all of the work, so to speak, to battle and get these things even recorded will already be done by the trust. And so the beneficiaries but need to show up with a willingness to learn and, to try to comprehend what is happening to the best of their ability based on what they witness as we go through it, and then tell people. And the trust will be revocable to the point where when there is the threshold defined in the Articles of Confederation of 30,000 civilians per republic to show up and register to vote in the republic, in the de jure constitutional republic of that state, de jure state, then that will have stood up the republic in that geographical area, whether it be the Republic of Texas, Republic of Utah, Republic of Washington, Oregon, California. And then the trust in that state will then dissolve, because then the body politic that has the authority to keep the federal government in check will be reconstituted, and the rules for that, how to do that, are right in the Articles of Confederation, the Federalist Papers, the Anti-Federalist Papers, and then the Constitution itself, as far as what makes up the judicial system and how to convene a grand jury, and under what authority it can be convened outside of the state, the corporate municipal state. That's all in there. And so that'll be the long-term goal, when that is established, the trust in that state will automatically be dissolved.
So what, Cody, what you're saying earlier is that, you know, for the fee schedule, like if you were going, you said it's like it's a matter of like putting pressure on somebody, but from what I gather,
Leverage.
From what I gather, you know, I'm just wondering, have you had anything like some of the values I have on my fee schedule that are, you know, and it's done under the estate, all right? And the estate has an EIN number, and
Good.
it's you know, some of these like so basically you're saying that you'd have to take them in their private capacity, all right? Because you or where would you start at? Would you do it like a federal court? Or like
That's a good question. That's a really good question. And so I think that the way that I'm going to answer that is once again in the lens of how I'm going to implement that concept in the trust. And so it goes back to jurisdiction. So the Constitution defines 3 jurisdictions. And in any proceeding, you can jump back and forth between the jurisdictions depending on the charges and depending on the accusations and the claims that are made against you. And so the way that I do it is I have a document that's defined that as the only entity to ever contribute any value to the implied trust of the state birth certificate. I have put it on the public record that and published it that I intend to reorganize this implied trust into an express trust of which I am the executive. And I sent the notices to the Secretary of State, to the governor, you know, to the Commissioner of Public Safety. Nobody said anything. So silence is acquiescence. So if they didn't say anything, it means that they acquiesce that I'm turning this into an express trust. And so the schedule of fees that I published, I placed into the trust. And so that's the way that you have to frame your thinking when you start developing a strategy on how to implement your remedy with your public officials. Is, am I going to do this from common law? Because if I do it from common law, in order to have privity of contracts in commerce, I need to do it between one living man or woman to another living man or woman. And in order to have the authority to issue an invoice for tort claims, for damages of any kind, I need to have a cause of action that I can clearly define that has what's called prima facie evidence to support the authority that I have to issue that invoice for damages. And so the fact that you have a published schedule of fees means that you have an action when taken by your elected officials against you that is contrary to the Fourth Amendment, Fifth Amendment, First, Second. You know, you put it all in there in clear black and white. And you do this based on the things that these policy enforcers do to you on a daily basis. They pull you over without a cause of action. You know, they ask you for your driver's license when you're not engaged in commerce. You tell them that you're traveling. They don't listen. You know, we got misprision of felony, misprision of treason. We got striking, disloyalty. We got a violation of oath of office, violations, violations under 18 USC 241 and 242. And so you put verbiage in your schedule of fees that matches those actions that we know they already engage in on a daily basis. And it comes back to an emolument violation, and which is when the state, federal, or local government pays their public servants to violate the Constitution, which almost every single one of their actions does on a daily basis. If you've ever had an interaction with any cop or sheriff, that's happened. I guarantee it, because they do it daily and they don't even know that they're doing it. And so to enforce that type of a charge against an individual generally ends up not happening. And so the way that you would enforce that action against one of your public officials, what you would do is have to go through the administrative remedy process. Because if you don't do that under banking law and contract law, there is no standing on which you can issue an invoice for the damages. So we take care of that through the administrative remedy process prior to even going to battle and prior to even talking to these people about the remedy that we're seeking for the actions that they took that were unconstitutional. And what that looks like is writing an affidavit based on what happened, referencing the documents that you have already cured on the public record, which the trust will have on your behalf if you choose to join. And so if you get incarcerated, detained, they can hold you up to 72 hours according to their rules without charging you with anything. If they do that to you for some traffic charge or something like that, what we do is we counter with, okay, we'll actually even accept that we owe you the fine under a conditional acceptance if you can produce the administrative remedy process that you cited, the statute to which the company bylaw to which the ens legis is in violation, issue a notice, produce certified proof of service for a notice of fault and a notice of default, and then a certified proof of summary judgment certification. Because if we had the opportunity to remedy that in writing, we would, because we want to make you whole if we damaged you. But before we agree to those charges, you're going to need to produce the international jurisdiction maritime wedding signature contract that proves that this ens legis is even subject to these statutes to begin with, because those statutes lack an enacting clause. And according to the Constitution, which gives you the authority to even exist, statutes aren't law because they lack an enacting clause. So I am here as the live man, grantor, contributing beneficiary to the Constitution, which gives you your authority. And all I'm asking for is proof that I even owe you this. And I'll pay it. Absolutely. If I've wronged you and I screwed up, then I need to make you whole. I agree with that. But you guys, I think, are out of line. I didn't get any invoices. I didn't get any notices. You didn't exhaust the administrative remedy process. I want you to throw this out now with prejudice, and I want you to leave my guy alone. Because if you don't, here's what this is a notice right here of these affidavits that the next time this happens, this is a standing matter. This isn't going away. We're going to let you go this time. But the next time you pull this crap, we're notifying the U.S. Provost Marshal. In fact, here's the proof that we already told him that this was going on. And we're going to give you an opportunity to stop making these mistakes and correct what you're doing and live by the constitutional order that you have an oath to uphold, swear, and protect. And everything's going to be fine for everybody. We're going to be left alone, and you're going to keep able to do what you're doing. Oh, and by the way, here's the UCC filings where we're the secured party creditor. The trust is to anything that happens. We're first in line, first in time. So if you choose to go ahead and implement this fine, we're going to agree to the charges. We've already got the bond issued at the Treasury for the bill of exchange under the trust, and all of the value that is derived from this, we're going to give you your net retentions. Everything that this court and the prosecutor and the judge would get if this was actually a conviction, we agreed to. We're not here to take anything away from you, but we are here to hold you to the Constitution and let you guys know that we're done. And if you come at this again, the next time we're not going to be nice. There's going to be treason charges. There's going to this is your one time. Don't do it again. Drop the gavel. Everybody goes home. You guys get paid. We get left alone. We can live. That's peace, and we can live with that. But if it's anything other than that, we're coming after every single one of you. And that's the part of it that I'm actually going to do here. I've got a hearing. It just got changed from tomorrow. The affidavits that I talked about that are going to be the precedent that this trust is going to have to stand on as far as status, and jurisdiction of one of we the people, the grantors. And without all this other nonsense that I'm talking about, the trust is just going to do it on your behalf in order to be the creditor to the ens legis rather than the debtor and the surety. And so, but with that status, the trust is going to protect your instruments to keep you out of behind bars for this nonsense BS and get you just about living life. And so what this will do is it'll provide a protection utilizing all those tools to apply leverage to the individuals, to let them know that we figured out the code. We don't care about their Federal Reserve notes at all. Not interested. In fact, you can keep them. We prefer it that way. But one thing that you aren't going to take is you're not going to take our liberty and our freedom. It's not going to happen. So take what you want out, give unto Caesar that which is Caesar's, and we want nothing to do with it. But the liberty and the freedom that the Constitution guarantees us in this arrangement is something that you will not infringe upon again. And if you do, be prepared to hang, because that's where we're going. We're gonna go to hang you, and we're gonna do it lawfully, but we're gonna do it through common law jurisdiction. We're gonna utilize our grand jury function. We're gonna stand on the claims that you guys are out of line, big time, on the oath that is yours to uphold. And we're done messing around. So you get one chance to do it right, and after that, it's serious time. We've had enough. So that's my vision on it. And of course, to enforce that is probably going to be contentious, but it's going to be after a writ of quo warranto, and it's going to be after all of the lawful standing and the remedy. We're going to exhaust all the way to the Supreme Court and the president if we have to before we get there. But that's what the trust is going to do, and it will have absolute, unequivocal authority and standing to do just that. And they're going to fight hard against it. And be prepared to be audited, be prepared to be arrested, be prepared for an institutional attack, because that's the only thing these people have is offense. But like I said, they're leaving me alone big time in my hometown and in my home state. But it's taken me 2 years of fighting with them and turning the other cheek, and then showing them how they've messed up. And then there's proceedings that are going on that they just abandoned, and the case numbers are gone about this thing that I had where they threw my ass in jail for 8 hours for asking the court clerk for an oath of office because I started referencing Title 42 and Title 18 that she was violating, and she's freaked out, absolutely freaked out, and freaking pushed the panic button and called cops. I got arrested for telling the court clerk she was in violation of 18 USC 241 and 242. She'd go to prison for 20 years. Those are the rules. So, it's definitely a vision that I have, and it might not be for everybody, because the payoff is going to be in the liberty and the freedom, not in the Federal Reserve notes. Now, we might get some if you run into some people that are really bullheaded and want to fight. We'll take it as far as we have to, and enforcing a invoice on the schedule of fees is definitely something that we can do to give this teeth. But in my experience so far, they back off before it gets to that point.
What if you could solve the crisis of AI data theft, or end surveillance capitalism, or government dereliction of their duty to protect our digital lives? What if you could seize the power to legally own, control, and monetize your data without anyone's approval and make a crazy amount of money peacefully and lawfully? This isn't a fantasy. This is the reality we're creating with the digital rule of law token that protects your digital freedom, security, and prosperity, that redirects a $1 trillion data economy built on your data directly into your wallet. I'm Alan Rodriguez, and I'm a data professional here to expose the great lie. Our data is not worthless. It's the most valuable asset we have, and it's being stolen from us every day. Let's think about all the data sources that you have. You have your healthcare data. You have your financial data from your bank. You have your purchase data from your loyalty programs. You have your location data from your phones and your cars. We have all of our home smart devices, our wearables, our entertainment, our social media, on and on and on. And here's the truth. Our data lasts forever. It can be thought of as an immortal asset. It's almost free to maintain, unlike other forms of property like land or gold, and we create new data every day, all of it valuable to a growing range of potential buyers. And you're the only one who can accurately combine all your data into a single digital person. And when all your data is accurately interconnected and productized the same way businesses do, its value increases exponentially. I've had the privilege of collaborating with pioneering chief data officers who are transforming data into a profit center. This collaboration has culminated in 2 issued patents and 10 provisional patents for enforceable digital property rights that we call the Digital Rule of Law Patent Pool. These patents are essential for turning data leaders into profit centers and for turning data into a financial asset and for protecting digital property rights for everyone. But here's the best part. We're tokenizing the Digital Rule of Law Patent Pool into the Digital Rule of Law token, allowing everyone to own a piece of it and to permanently protect its evolution. This is the only way to ensure digital freedom, security, and prosperity for everyone. Imagine a world where your data is truly yours, protected by law and cryptography, and you get paid every time it's used by others. This world is possible with the Digital Rule of Law token. This is not another hyped Ponzi scheme cryptocurrency. Digital rule of law is backed by a growing patent pool with real adoption and real revenue. It's a revolutionary approach to digital property rights. By embedding ownership, security, compliance, and royalties directly into your files, we turn your data into valuable and protected assets, protected from theft, surveillance, and censorship. This approach gives you the power to reclaim what was always yours, without begging or waiting for governments to grant us our digital property rights. Here's what most tokens don't tell you. They're built on hype. They're built on promises. They're built on speculation. The digital rule of law token, well, we're different. We're backed by a growing patent pool, a $1 trillion enterprise licensing market for data profit centers, and tokenomics engineered for real royalties and real returns. With the digital rule of law token, you gain 4 unprecedented powers. You own the digital rule of law patent pool, which protects digital property rights for everyone. You control the standard for data financialization with your vote. You protect your data and digital rights from corporate capture and weaponization, and you earn royalties from every data product and financial asset created. This is your invitation to join the select few who recognize what's happening, who see the future, and who want to become a part of building it and profiting from it. We're making history right now, but we need pioneering leaders like you to make it happen. Imagine a 100x return in 2 to 3 years. Imagine turning 5K into $1 million, or 10K into 2 million, or 25K into 5. I know this sounds crazy, but this is what accredited investors earn when they successfully launch a new token. And because you are my friend, the SEC allows a maximum of 30 non-accredited friends and family investors to earn returns only available to accredited investors. This is how we take back control. This is how we create generational wealth. This is how we build real digital freedom. The question is, will you profit from it? If you regret not buying Bitcoin when it was $1, this is your second chance. I welcome you to explore the website and learn more, to join our weekly Digital Rule of Law live stream, and support the movement to reclaim and protect your digital property rights. I hope you'll join us. We're having a lot of fun, we're doing the right things, and we're going to make a lot of money.
I've heard of a couple instances where, the debt was issued to a collection agency, a third-party collection agency, and it ruined that individual's credit. I mean, they can't borrow money. They're done. The credit cards were canceled while their loans were called in. Because, if you got a couple, for instance, I just issued an invoice to the municipal local attorney here in the city and borough of Sitka. Gal's name's Rachel Jones, because she's presenting the interests of the city and borough of Sitka in this exact scenario where I've charged them, the city and borough, $20 million for a violation of schedule of fees on both on emolument violations and then also on violations of their oath of office. And so I just picked an amount based on the Title 18 violations that were relevant because of the unrebutted affidavit that I put on the public record and sent to them and gave them an opportunity to rebut, and used contract law to write that affidavit. This is how you remedy it. This is your opportunity to cure. And then when they were silent, I completed the administrative remedy process of a notice of default, and then a notice of certified summary judgment due to silent non-response. And that's a court of record. That is so now they're trying to argue about that. And I'm telling you, had your opportunity. There's no arguing. This is over. This is a settled matter. Your silence is agreement. Now, if you want to talk about, the validity of unilateral contracts, well, let's go ahead and talk about that, because the very grounds on which we're even having this dispute is based on the fact that my government thinks that I'm subject to their statute when I'm not, because I don't agree to that. And I never did agree to that. There was never a disclosure of what the signing of the Social Security, selective service, the driver's license. You guys didn't tell me any of this. The marriage license, none of that is enforceable to be subject to statute in my personal private capacity, because nobody told me that was a thing. And so anyhow, but they don't want to get into that on the record, because then it you put all of their accusations back on them and utilize their own fraud against them, and utilize the same standing that they utilize in order to try to hold you to their rules, and by holding them to your rules from us, but you're doing it from a superior status, standing, and jurisdiction, which always wins in court. And so should we get to the point where we actually collect from a court or a state government, awesome. I'm down for that. But that's not my definition of victory. So I don't force that. And I utilize those processes of charging invoices to the individual that's in the office due to their oath of violation, or violation of their oath of office, and then come up with every single Title 18 accusation I can that seems relevant and just throw them an invoice. And if they don't rebut the authority and the stand, all they do is argue about the price, the cost. Well, they've agreed that the standing is there. And that's how they get you and to agree, to all this stuff. You start arguing about the price rather than whether you owe them anything or not to begin with. And so anyhow, once again, it's really a strategy to get to the greater goal that I personally have, which would be to stand up the republic and hold our public servants accountable to the constraints in the Constitution. And in order to do that, we have to have leverage and tools to outmaneuver them when they try to come after you. And in my opinion, in the way that I like to look at the schedule of fees, it's really just a tool to put in that box, to obtain those ends, to put leverage on the individual to get the institution to then settle. And that's what my goal is with this situation. It's a $20 million invoice that's valid. And the city is trying to say that I have no standing on which to issue the invoice, which they're wrong. They're going to lose. And so what I'd like to see happen in that instance is I would like to see the courts either throw it out, and then I get to the negotiation table with these individuals in the city where I can tell them, here's my goal. I want you guys to understand that what you did was wrong. I want it acknowledged, and I want you to tell me what you're going to do to make sure that this doesn't happen again. And in order for that to happen, you're going to need to listen to me long enough to let me explain how I did what I just did. I'm willing to do that, because as long as you guys understand it and know it, then you can follow it, because I'm in the position of power here as the creator of government. You guys are the ones that violated your oaths or didn't have them even on file. So I'm not the one on trial here anymore. You guys are. So let's talk about remedy. And what I like to see for remedy, let's go ahead and turn this into your insurance company. That way the resources aren't taken away from the city. The pain that you guys will feel will be the fact that you're going to have to pay raised premiums for a while and explain to people why their taxes are going to go up because you guys screwed up. The value that I get is going to go right into the trust to proliferate this exact message across the country to anybody that'll listen and help individuals that are having the same trouble, because my idea of the America that I want to live in is an adherence to what's in the Constitution. That's the rules that we got, and that's the rules that we need. And so if you guys want to talk about that remedy, then I'm all ears. And if you don't, well, then I'll see you in court. And I'm gonna keep going until you guys learn that you've lost already. And when we get your insurance company involved, what that's going to do is that's going to put extreme pressure from the insurance company onto the municipal corporation to no longer commit these violations, because that insurance company is about profit. And if they have to pay out, that cuts into their profit. And so they are highly motivated to teach the municipal corporation how not to commit emolument violations. And so it's a self-correcting system when you utilize what they value, take it away from them if they continue to commit these things, and it's a self-righting situation at that point. So that's the implementation, and that's the usage that I see in the value of the schedule of fees.
So when you're talking about their insurance, all right, you're talking about their bonds and their private capacity. All right?
Well, no, I mean, there's that. I mean, you could go after that too, but the municipal corporation itself has an insurance policy. It has to, because it's doing business. It's in the business for profit. I mean, that's what it is. And so the rules of commerce are that you need to be insured. It's a limited liability situation where liability is socialized, profits are privatized, and that's the game that we live in. That's how their system works. So that is a vector of attack to involve corporations that provide the insurance to that municipal corporation in order to create a self-righting situation where the profits of the insurance company are going to dictate the way in which that municipal corporation conducts business with we the people. So they'll still continue to do the same thing to U.S. citizens. And honestly, that's fine. Go ahead, because it's going to show those individuals how much better it is to be on this side of the arrangement. Instead of being the surety to the debt, you know, being the creditor to the entity itself. That's the side that you want to be on. And in my opinion, and so those individuals that are seeking that without comprehending, number one, how the fraud against them puts them in the debtor status, and also the convoluted way in which you get out of it, which has taken me years to even come up with a plan on how to deal with it, let alone understand it. You know, it's going to eliminate that painful learning process of each individual having to go through that. Because I mean, honestly, if I wasn't in the situation that I am, where I had the time to, I mean, this is my full-time job. I mean, I've abandoned my business, and, you know, I'm divorced. And so, I mean, if you've got a family and a job, forget about it. You don't have the time to learn this stuff, even if you have the capacity to comprehend it, which I think most people do. It just, you know, this takes a while because we're so used to living in this other system, and it's so convoluted, and it's so hard to know who you are in this system, in this matrix of control, because everything is meant to oppress you and hold you down, and they do a very good job of it. So hope that sheds a little light on it. I don't know if that answers your question, but I hope it does.
Anybody else? Steve? Nothing? Kid, you want to talk about the rice?
Talk about the rice.
Yeah.
Hey, Cody.
Yeah.
I recently had a kind of 10-year probation. And
I'm sorry, what about 10-year probation?
I recently was given a 10-year probation.
Okay.
Where I had to check in every month to the probation officer. So I decided to, and they're charging me for the community service. It was $7,000 for that, and they had some other fees. It totaled about $10,000. So I sent them in 10,000 grains of rice, and didn't hear anything more from them. I went to check in at my first probation hearing, and they said, "You're not in the system."
See?
Fantastic.
We're
Fantastic.
10 pounds of rice to free some other people.
Yeah. That's that. And did you have to cite the authority on which that was legal currency and lawful tender to discharge the debt? Or, okay.
Yeah, I cited HJR 192. They can't specify the species. And
That's
they
right.
use 3.603 that tender is offered. If it's rejected, it needs to be discharged.
There you go. Exactly. Perfect. And did you do that as the executor of the estate that received and accepted the presentment from the municipal corporation, or did you just do that in prime persona?
And just as myself, not as the executive.
Okay.
That's a good idea. That make it stronger.
Well, I think that it's a line that I think that the corporation, that the government services contractors, the public employees, are going to eventually identify and understand and comprehend, and use that as, oh, well, this payment does not adhere because we have no privity of contract. You're the living man or woman, and this is not applicable to the jurisdiction that you're coming from. If you agree to the charges as the lawful man or woman, then you need to perform. And so, you know, you don't have access to HJR 192 as the ens legis itself. And so jurisdictionally, they would have an absolute conundrum if they tried to do that to you, because then you could stand on that same separation of jurisdiction and say, well, then the court has no in personam jurisdiction to even hear the controversy, which is something that I would like them to do. And so the way that you did it, I would want to continue to do it that way, so that they maybe would come up with that defense, and then you would force them to have to pick a lane. But the fact that that's how they handled it, that just went away, tells me that they're aware of all of that enough to know that they don't want to go down that road, and it's best just to leave you alone. And that's exactly what I want to do for all the people that want to be beneficiaries of this trust I'm talking about. As long as they commit also to, when they're sharing their successes and the freedom that it imparts and how the government will finally leave them alone, there's also a civic duty that comes along with that to participate in standing up the republic according to the Articles of Confederation. And so, the homework and the study would be to read that and study it and be a part of that process and know what it takes to, convene an assembly, and of we the people, and come up with, ways to put the will of the people into a trust in order so that the trust can then proliferate that will in commerce with the public servants. Which is really, and once the republic is stood up, you won't have to do it that way anymore. So, but yeah, like that right there, like that testimonial, I would love to have that as on a website where this is going to go, and, do it by donation to keep the website up. It's going to get attacked. It's going to get spammed. It's going to take resources. But me personally, I don't need anything for this. Like, this is, the result of restoring liberty to the country, the way that our founding fathers designed our system of self-governance to work. I want to utilize those tools and make our public servants hurt when they violate them. And by make them hurt, I mean have them have sleepless nights like we have when we're dealing with this stuff. Make them feel what it's like to have the long arm of the law coming down on them for something that they didn't even know that they were subject to. But then, instead of what they do, incarcerate us and ruin our lives, we're going to do it the right way, according to Scripture. And we're going, if they repent, confess and repent, then they're going to be forgiven. And I just, we're not about vengeance. That's not our department. And so, the schedule of fees and the Federal Reserve notes and all that kind of stuff, we start getting into that. It's, the money is the root of all evil, right? We need to not make that the prize. So that's not going to be, I'm understanding that this is going to take resources, and you have to pay, like I said earlier, you got a job, you got a family, you got a life. You can't do this for nothing. There's got to be some compensation. But the yachts and the access to the trust and the private jets and all that kind of stuff. Now that's not the way, in my opinion, that you can do this and end up in an honorable situation where you fight for the liberty, because that's what the country needs. I'm about restoring the posterity, restoring the life and liberty and the constitutional order to the posterity. That's what the goal is.
No. Anybody got a question? Okay, Cody, I think that's all the questions. Anything else? Anything else you want to talk about?
Anybody interested?
I am.
Yeah.
That's awesome.
Okay. Well, what I'll do is I will get the trust indenture polished up in the next little bit. I've got 5 days now until I need to put a filing in and it's going to rely on Article 1, Section 10, constitutional lawful money, and the definition of that that's codified in Title 12. And then I'm going to also have that hearing that was scheduled for the 3rd that they moved to the 8th, never told me, and didn't give me a notice. Oh, no, it's on the 8th. Huh, sure it is. And anyway, so there's some nonsense going on there, but I think that this court is starting to understand the significance of the documents that I have filed. And so I'm going to see what happens, and I need a little bit more information in how to word a few things. But once I get the indenture polished and done, what I'll do is I will email it to everyone, and then we'll probably start just with a website, that the name of the trust is going to be United States of America Constitutional Republic. That's going to be the name of the trust, and it's going to have an EIN and a bank account, and it's going to be a pure contract trust, which is a business entity. And so it'll have standing to be sued on behalf of its beneficiaries. And the sovereignty of we the people is what's going to be placed. That is going to be the res of the trust. And so the indenture will define what the trust can and can't do, duties of the trustee, what the board of trustees is made up of. And so we'll need individuals to populate those offices. And so anybody that's interested, and the way that the trust is going to be written, you can be a contributing beneficiary. So you can be a trustee of the trust or an executor at the same time as you're one of the beneficiaries, as long as you, put the proper autograph and the proper paperwork. And there's going to be an oath to defend and uphold the Constitution, the original Constitution, that you'll have to sign. I'm getting certified copies of the freedom documents right now from the National Archives. I had to FOIA them. I had to fight them for them, but I'm going to get them now. And that's going to be the Declaration of Independence, the original. It's going to be the Bill of Rights, and it's going to be the Constitution itself. And other business of the trust is going to be to amend those founding documents of the trust to allow, because currently, 3/5 of every Indian and a distinction between individuals based on their color of their skin, and then, but not only are we going to amend that indenture to modernize it, where ethnicity is not, and, it's about sacred honor and pledge of being an American, no matter your ethnicity or your background, or your gender or any other affiliation whatsoever, as long as, you adhere that the oath to the Constitution is your superior oath and all others are disavowed.
It froze up.
Ask him if he can hear you.
Can you hear it? You can't respond if it's frozen.
Well, he can still hear you though.
Can you hear?
Looks like he might be frozen.
Here.
And get a certified copy from the document custodian of the founding documents, and you'll need to affix your autograph and your official seal to pledge your sacred honor and support, uphold, and defend the same way that the founding fathers did. And so that'll give you standing as an individual to have access to this constitutional private jurisdiction of one of the private citizens of the Republic,
So,
with
Cody,
the express and told to stand it back up according to the rules in the Articles of Confederation.
Cody, I got a question. If we do
Sir.
this, would it have any effect of changing our status from citizen to sovereign to national?
Excellent question. Excellent question. And so the way that I comprehend that whole situation is that the ens legis is the state national. The implied trust and the business entity, the transmitting utility that was created upon registration by your mother by signing as an informant on the application for a birth certificate, that individual entity can never hold your sovereignty. Unalienable rights. They cannot be contracted away. And so that'll be in the indenture. And case precedent in the Supreme Court will be referenced to assert that authority, that at no point ever was the living man or woman who was, brought into this world on the soil of the Republic ever had the capacity to contract away those rights and that sovereign status in this constitutional republic. It doesn't exist. You can't do it. And anybody that claims otherwise is warring against the Constitution and the natural order of this republic, and they'll be held accountable. And so the main thing that I want to say and reiterate on response to that inquiry is that the ens legis, the entity, the corporation that has the social security number, that has the state file number on file at the vital statistics or the county where you were born, that corporate entity is not you. It is only the account that your federal government created on your behalf in order to interact with them and receive the benefits of that federal government being in existence under the authority to regulate commerce. And so all of the benefits associated with being a U.S. citizen or a state national is put into that trust. And that is what you are pledging to this constitutional republic, with the sole intent of enriching no person, man, or woman, but with the sole intent of utilizing the resources derived from your pledge of that sacred honor to standing up the republic. And so the individuals that are engaging in the process and spending their time and their energy, there'll be compensation, administrative fees, that the trust will pay to them that it can afford for occupying an office of the trust and that kind of thing. But but the benefits themselves that you are entitled to through that ens legis are yours to keep. So it's not like you're going to be paying the trust your Social Security payments. because you could still get those as a state national. You're not going to be beholden to the trust for, any administrative fee for, the trust helping you get your private property into the land patent status, so you don't have to pay property taxes on it anymore, and to get an allodial grant deed rather than a warranty deed associated with that private property. You're not going to have to pay any set fee to the trust for anything other than, the stated intent of the trust, which is to contribute where you can, how you can, in any form that you can, from the resources that are derived that you might gain in a proceeding. So, like, let's say, we end up suing the county or the sheriff in, going after their bonds, or, we come up with a standing to issue an invoice for damages based on the $10,000 a minute because they threw your ass in jail for 2 or 3 days. The recovery that we might get on your behalf for something like that, we ask that you pledge that to the trust in order to carry on the business, because you wouldn't really be able to get that monetary compensation, that financial compensation in Federal Reserve notes without the trust. And so we ask that the trust is going to ask that you donate some of that in order for the trust to continue to exist, pay its officers, continue to proliferate the message, produce the website, that kind of thing. And so but yeah, I think that the main thing to remember is that Martin versus Lessee of Waddell, the opinion of Chief Justice Marshall at the time was that when the revolution started, the people themselves became sovereign, and unalienable rights given by God, granted by God, cannot be contracted away. Even if you tried to, even if you knowingly tried to contract them away for some benefit, you can't do it. It's not enforceable, not under this constitutional republic. So you assign the citizenship status inside of the corporation's world to the ens legis that you want. And I think that the best way of doing that is definitely the state national, in my opinion. But if somebody has reason to stay a U.S. citizen, then, as long as they're appraised of the liabilities that they're subjecting themselves to with statute, code, and regulation, to be the surety to those violations. Well, if that's what they want to do, then go ahead. But the state national or the U.S. citizen distinction exists primarily and only in commerce and only inside the corporation.
They're frozen up again. Let me see.
Am I back?
Yeah.
All right. Did that make sense, Steve?
Yeah, that's great. Also, you mentioned a website. Is that generated yet? Constructed?
Nope. And I am terrible at that. So anybody that wants to help,
We can find somebody.
but on the website, it's just going to be, everything, an introduction and basically a summary that I just said that, this isn't to make money. We're not a 50c3. We don't pay taxes. This is constitutional jurisdiction. And the mission statement is going to be to stand up the republic by showing people the power of the founding documents and the Constitution in court, to educate our public servants as to the jurisdictions that the Constitution defines and live inside of that constitutional order in relationship to our government. And get these tyrants, knock it off.
Another situation I want to get your opinion on what you might say about it. The FBI is investigating the Republic of Texas. Were you aware of that?
Yeah, of course they are.
Okay.
That's what they do. They investigate stuff.
Last week, my mechanic found a tracking device in my car, and he disabled it. And he said,
Okay.
So I went there today to get him to pull it out. He said it was already gone. So that's what you can say.
What kind of tracking device was it?
There's a long black, had a red light on it.
Okay.
It was underneath the dashboard.
Yep.
Should we all be looking for that in our cars?
Oh, well, like I say all the time, You know, of course they're surveilling us. I mean, I made sure of that a long time ago in my personal capacity when all this started, because if anything ever happened, they ever tried to get me for anything, I wanted everywhere I've been, everything I've said, and everything I'm trying to do on the absolute public record. Because, I mean, it's not that I'm not willing to go fight with these people and shoot at them. I am. And they should know that, because it says that I'm allowed to in the founding documents. They're the ones that are out of line. And the fact that that was put on your car is just, you know, we're over the target. So just plan on anything, anytime. I mean, treat me like I'm a Fed, you know, but if I ever pick up a rifle and go against the tyrants that are warring against the Constitution, I'm going to have a perfected administrative record citing the constitutional jurisdiction, the fact that I'm a grantor to the Constitution, I'm upholding and defending the Constitution. I'm going to have prima facie evidence that's published and left in numerous places, already sent to the U.S. Provost Marshal, the Judge Advocate General, the Attorney General, the U.S. I mean, I'm going to tell them preemptively, here's what's going on. You guys are out of line. You want to come and fight with me? Let's dance. I'm not afraid to die. We all got to come in at least once, but I'm going to try to do it the right way first. And according to the rules that the Founding Fathers has given us. And because that's the only way that you have the moral authority to actually go kinetic. And I truly believe that it just is a matter of education. And these people are just compartmentalized legal idiots, and they don't understand what even liberty and freedom is. And they don't understand that they are the tools of the tyrants that are causing all of this nonsense. And they think that we're their enemy, and we're not. We're on the same side, but they don't see it that way yet. And so I'd say, let them surveil you and let them see what kind of person live like Christ would, man. I mean, just show them the people that we are. I mean, they're gonna, with FISA and all this other nonsense. I mean, I got freedom of speech, and I've got a right to defend myself against all enemies of the Constitution. And right now, they're not doing their jobs. They're the enemies of the Constitution. They just don't know it yet. So, I mean, the fact of the matter is that I would imagine that they're probably hoping that we're a militia group that wants to, you know, like organize and march on Washington and all that stuff. And you know what? Maybe that's in the cards at some point. I mean, you know, the Founding Fathers had to do it, but the Founding Fathers had standing because they utilized the rules of commerce, and they didn't have the Constitution to stand on like we do. They had to just say, this is inherent in human nature. And you guys, we don't care that you think we're wrong and that we're beholden to this king. We're not, because we didn't agree to it. And if you want to try to enforce that we're beholden to this other tyrant across the ocean, then come and take it. Because we're not playing ball anymore. And so it's kind of the same philosophy. And so go ahead, let them. I hope they're listening. I want them to listen, because I want them to know that they're out of line and they are the ones that are wrong. And I'm not interested in taking their houses. I'm not interested in getting a gunfight. I'm not interested in getting pulled over anymore. I don't want to hurt anybody. In fact, I go out of my way to try to be kind to people these days, right? Because there's just not enough of it in the world. But I will not take their shit anymore. And all I want to do is talk and tell them why I think what they're doing is wrong. But they aren't willing to they think they're right all the time. So, all right. Let's dance then. You think you're right. You got the ability to surveil me and see who I am. Yeah, I'll show them exactly who I am.
You mentioned being.
And they got nothing. Live like Christ, and they got nothing.
Yeah, you mentioned being kind. I saw last week that when somebody witnesses you being kind, it has a positive effect on their soul as well.
Right, and I mean, I'm kind. I mean, like, you know, not a doormat, but you know, like I try to, you know, just like what the Bible says about how Jesus would go to the dregs of society and try to help them, right? That's where I'm at, you know, and that's honestly, those are the people I think that are sick of it. They've had enough of the nonsense, and I think those are the people that are going to join us. And so, you know, like I said, it's all about intent, right? And so if the intention is to forgive and educate them and let them off the hook, I don't want to take their houses. I don't want to take their retirement. I don't want anybody to go to jail. But if they're going to sit here and continue to proliferate this nonsense and think that they're in charge of everybody, then if that's what it comes down to, then that's what it's going to take, and so be it. So I'm not responsible for their behavior. They are, and their actions. Just how I'm responsible for mine. I don't get a pass. Ignorance of the law is no excuse, right? Well, that's the door that swings both ways. And so, I would say it's, if you don't want them knowing where you're at, then take it off. But I would find out who put it there. Where's your warrant for this?
Anything else?
Anybody else?
So we got the right to freedom of association, and the fact that we're talking about, commercial ways to gain standing, to ask questions and give opportunities for our public servants to correct their unconstitutional actions. Please come arrest me for that. Please.
Yeah.
Please come arrest. I can't wait to tell that story in court. Please come get me. Come get me. Right? I mean, come on, right?
Cody, is there a website that we can go to donate?
Not yet. So I think that I don't even know what that would be, but what needs to happen first is there needs to be a notice of a public meeting for sovereign individuals who want to adhere to the Constitution. We need to put this in the public record, so maybe even in paper, and then save the paper itself and give 30 days for the notice of when and where the meeting will be, and then schedule the meeting, and then call it to order, define the Constitution, assign a secretary, and we'll need to have an agenda for the meeting. And I will create the trust before then, get it an EIN, and then if somebody wanted to, preemptively volunteer to be the treasurer or some sort of, an office in that, they can be nominated to be the treasurer of that and then be sworn in at that meeting. And so, it's gotta be by the book in order to give this entity the standing and the status that it needs to engage in commerce according to the administrative record, because that's the standing that we're going to be utilizing to ask our public servants questions. That's what we're going to be doing. We're not going to be making demands of them from this trust. We're going to give them, Sun Tzu says, you need not fear the outcome of 1,000 battles if you know yourself and you know your enemy. Well, and Sun Tzu also says that you always leave your enemy means of retreat. So, we're going to write into this public meeting that the goal is to educate our public servants, give them an opportunity to confess, repent, and be forgiven. And we're not, and it will be the ground, the written indenture of the trust that amnesty and forgiveness is the policy. Should they correct their ways, drop the charges, acknowledge what they need to change about how they're operating, and leave us alone, unless there is a first-degree witness, signed affidavit, presentment by a grand jury, and then the trust will hold our own beneficiaries accountable to make the injured party whole. And if there's criminal implications, we're about the rule of law in this, but we are also about, one or two chances, and then the consequences are coming. So that's where, the status, standing, and jurisdiction of this entity needs to be by the book. And so any donation that is administered now, the entity isn't in existence yet. It's not been convened by a body politic of we the people. And so, the association needs to be in existence before it can accept any value. And so whatever the method and the vector of that is, probably through crypto, I've got a private membership association that I've written the bylaws for that is called the Lawful Money Exchange. And in that entity, it denominates everything so that all matters are in the constitutional jurisdiction. Anything over $21 is a matter for the Constitution, applies in commerce. And so we'll use those thresholds to gain that standing with this entity. But it absolutely has to be in existence before it can accept any value. Otherwise, that's a road I don't want to go down. We've got to do it by the book.
Hey, Cody, I think you're in they operate in trust, and that's all they operate in, and the people don't know it,
Yeah.
So they're basically just exercising your trust for you. And one of the ideas, so your trust, right, is going to be the blanket trust over these other people that put their trust under it. You could probably put their all caps name in the under the blanket trust as trust property. All right, and therefore,
Good.
if that property ends up in jail from a traffic stop or whatever like that, you could actually maybe retrieve them. As far as I don't
I
know.
think I hear you. I hear what you're saying, and that is a concept that I've come across, that I've seen some people able to gain remedy over. And I'm not opposed to that, but I think that that would probably be something, because I don't believe that you want I personally wouldn't want my ancillary just transmitting utility that I'm the executor of, that was created by the state on my behalf, that they assumed that I was the trustee and the surety and too, rather than the contributing beneficiary and executor of. I think that to go through the process that I described, where you utilize the commercial maxims of contract law to notify your public servants, Secretary of State, Attorney General, Governor, Commissioner of Public Safety, and whoever is in charge of either the county commissioner, the vital statistics, or whatever organization where that document is held in trust by your public servants, whether it be vital statistics or whatever they call it in your state or county. I don't think that it's a good idea to put that asset in the control of this business entity. And the reason why I think that that's not a good idea is because the sovereign needs to be able to handle their own affairs. And if the sovereign decides to obtain counsel through next friend in order to issue a power of attorney for a specific instance to, say, one of the trustees of this trust I'm talking about, the United States of America Constitutional Republic, with the sole intent of providing resources to individuals who want to live under the freedom documents and not the statute, code, and regulation, there would be a vector there to have standing to have a legal and lawful standing to provide that next friend counsel in matters where the executor needs assistance, should there be something like that that comes up in their life. But the fact of the matter is that I think it's a much superior standing to have your transmitting utility and reorganized as an express trust, of which you, the sovereign, the living man or woman, are the executor to. And then the other thing that the trust I'm talking about creating can help you do is to file the security agreement, the hold harmless, the indemnity clause, all these commercial instruments that give the executor status and standing to handle the affairs of that entity just with the municipal corporation, should there be some sort of a presentment regarding statutory code or regulation charges, to which maybe there is an incarceration or detainment. But we go through that process when we get there, and the only thing that the trust that I'm talking about is doing is providing real world evidence with standing on these constitutional remedies that I've discovered, to both gain validity in the movement with real world observational results that you can share with people around you. Then you can have the discussion about what the benefits and the drawbacks are, the impact that it has on your ability to borrow money from the central banking system. All of a sudden that will open a discussion with what the central banking system is and why the lawful money exchange is way better. And so, I've already got the conduit and the infrastructure, the intellectual infrastructure built into associations and private membership associations and private contract with other contract trusts to move the value around to, that's associated with penalties or countersuits, or even, your own personal finances with, your work and going to the grocery store and debit cards and all that kind of stuff. We can put all of that behind a firewall that this trust will create. And so I think that's a great idea. But the implementation of it, I think that, would be superior to have the sovereign retain the executor status over that ens legis, because the sovereign is the creator of government. And what it does is it puts your reorganized express trust, because it's a creation of we the people, on the same status and standing and jurisdiction as the state government and the federal government itself, because the federal government is also a creation of we the people. And in commerce, that which one creates, one controls. So, and that's the reason why I think that would be a superior way of operating to obtain remedy in these circumstances, to keep the sovereign in executor status personally to their individual ens legis. As far as, you know, the individual circumstances arise concerning, and, you know, like I could think of, I could sit here and rattle them off, you know, just things that I've come across where it might be advantageous for one proceeding or maybe a certain circumstance to put something of the ens legis, like a benefit or something like that, into the trust that I'm creating, for a short term with a power of attorney to handle it, you know, in order to avoid something or some, you know, but I think that would be a case by case basis, and we could absolutely do that, and if it's beneficial strategically for the situation that we're in. But to do it preemptively, I think you would be sacrificing that superior status, standing, and jurisdiction of the sovereign in that process. And I don't think that's something that you should do unless it's a benefit because of the situation that arises, if that makes any sense.
Anybody else? Okay.
We appreciate it, Cody.
Yeah. Well, Cody, thank you so much again for talking to us.
Absolutely. So the next step in this trust is, if there is anyone that wants to volunteer for the starting the infrastructure for the website, and maybe offer, I don't know if I mean, I don't really know the central bank system, you know, but it would make sense to probably have a Zelle account and, you know, some sort of a larger central banking, maybe a couple of them. I would bet that there's going to be some nonsense and malfeasance on the central banking side. So to be able to have the assets of the trust, if it accumulates anything into a diverse, different set of, you know, individual companies, would probably be a good plan. But then, you know, I can also distribute the private membership association bylaws. And I asked for your mailing address not long ago, and that's exactly what that was for. So I'll send that in a way that it's traceable, make sure it gets to you without being messed with. You know, Steve's comment about how, you know, we're being surveilled, assume that at all times. But just operate from that assumption that, you know, anybody in the room that you might talk to, you know, maybe they're not a Fed, but assume that the Feds are listening to them and by consequence listening to you. You know, if you have a Facebook account, they have the right to listen through your phone. In fact, if anybody with a Facebook account and a wireless router with a subscription service is in the room, if your smartphone is in the room, then they also have the right to listen to everything that's being said through every smartphone that's in the room. And I say let them listen, because we're not talking about anything but lawful remedy here and holding our public servants to the oath that they are required by law to have. That's all we're talking about. And if we need to talk about something else, if they, you know, continue to behave the way that they behave, we're going to complete the administrative process first, and all the way to the president. We're going to exhaust all administrative remedies before any other discussion about any other action is taken in these meetings that I want to have. It's you know, like I said, the founding fathers, they took up arms and they decided to act, but they had the standing to do so. And they made sure that they had the standing by documenting it, following the rules, and going through what they went through. And so we are going to absolutely follow the rules, and we're going to give every single policy enforcement, investigative, you know, public official, doesn't matter what they've done to us, we're going to give them the opportunity to stop. And as long as they do that and start changing their ways and go by the, I mean, and here's the thing, maybe we don't quite have the rules right? So what this will do is it'll give our adversaries an opportunity to actually discuss with us what the Constitution means to us. Maybe we have something wrong, but we're not going to find that out unless we actually have a discussion with them. And sooner or later, that will happen. And when that happens, you know, just like the senator from the Republic was discussing with me the other day, like, you know, that's what we want. We want to be able to have a good enough relationship with these people where they know that they can sit down and talk with us and know that we mean business and we're ready to take it as far as we need to. But we're going to exhaust all the remedies first, because we don't want it to come to that. Because these rules have already been bled for. The battle's already been won. The problems that we're having with our public servants and our government are stupid problems to have, because the rules are there and they're clear and they're violating them and we have no remedy. So that's what we're seeking. We're seeking administrative remedy, and to have them show us that they know what the rules that they're supposed to follow are, and have them to start following them. and we'll play by the rules from here on out as long as they do. But anyway, so that as long as that message is the message that is proliferated, that yeah, this has teeth in the end, but we don't want it to get there. And I just don't see how any statement of that sort is come and get me. I'll tell that to any judge. That in fact, that's what I'm telling them. That's exactly what I'm telling them.
Hey, Cody.
And it's working, which is what
things.
I want.
I heard a couple things. I use my browser on my phone to access Facebook, but I refuse to install the app. Is it through the app that they?
Doesn't matter. You got an account with Facebook or any social media company. You're tied into Palantir. They're listening to everything. That's how they. So the DARPA created an AI weapons-based information system years ago, and the CIA produced LifeLog, and then all of a sudden Zuckerberg came up with it, right? I mean, you look at that family history. He's part of it. I mean, give me a break. He didn't come up with it. So Facebook is a surveillance tool in itself. And so when you get an account, part of the terms and conditions is that your personal biometric data information is collected. And they say that it's only for, for targeted ads and for only in their internal purposes. But what they don't tell you is that part of their internal purposes is they have a contract with the federal government, to flag individuals and to, in their interpretation of what's best for the country and all this kind of stuff. And so, that like you'll be in a room talking with people about something, what you're going to do this weekend. We're going to go to the lake and yeah, we're going to take some beer and we're going to camp and kids like Doritos and it's going to be great. We're going to have a great time, go do a little fishing. And all of a sudden, everything that you might need to go on that little weekend trip with the kids, you get, sale on Doritos at Sam's and, take a cooler. And I mean, so the targeted ads that those platforms, that technology that creates those targeted ads based on the things that you say in the room to others around you, that's derived from a weapons-based psychological warfare system that DARPA produced 20 years ago or longer. And so that same technology is creating an AI doppelganger of you individually. And that is used by the federal government to basically conduct pre-crime. And so the reason why the federal government is, the FBI is investigating people like us is because the algorithm is flagged us. Because according to their training of their large language models, which that weapons-based information system is, we're people that are a threat to their power structure, and their AI is a reflection of their own consciousness. And so we're labeled as a threat. And so to them, we are a threat. So how do we negate that threat? Bring it all out into the open and prove them wrong. Let them treat you poorly, turn the other cheek, and act in honor. Enlightenment through contention. See what you're made of. Honor thy adversary. And I've been using the principles of Sun Tzu to do this, and it's worked out really well. And so, the ability, like I was saying before, those who have the ability have the responsibility. And so, as far as utilizing the information systems and communicating with the way that you are, anybody that I'm affiliated with in this trust is going to have a trust indenture to follow. And that's going to be the mission statement. That's going to be the philosophy, is that it has teeth in the end, but we are going through the process no matter what they do to us before we take it that far, because, we're already labeled as the outliers and the problem. And we're going to have administrative remedy standing before it comes to that. And I honestly, I don't believe it's going to come to that. I think that this process that I have a plan for is going to put the individuals into liability in their personal capacity through their bonds and through the violation of their oaths, to the point where, we issue them an invoice and then all of a sudden it gets down to brass tacks and we'll go, here's the trust indenture that we're operating from to even get this far. If you apologize, repent, confess, then you'll be forgiven. We'll drop all of this. We don't want to take your house. We don't want to ruin your pension. We don't want to ruin your life. That's what you've been doing to us for a really long time. But our creator, the same guy that got us here, says that we don't get to do that back to you according to what we're trying to accomplish. And we need his favor to fix this. So it ain't us. We ain't that good, but we're trying to be. And so if you can join us and knock it off, we'll let you go. But if you don't, this is where it's going. And game on. Let's dance. Let's take this as far as we need to. It's up to you guys. You're going to knock it off, we walk away and it's over. It's absolutely over, and we'll even put it in writing. Sign any right to tort claims. We don't want anybody to go to jail. We don't want you to lose your house. We don't want you to lose your pension. We don't even want you to lose your job. We just want you to do it the right way. That's it. That's all we're asking.
Cody,
So, I mean, I don't think there's any more clean hands than that.
I want to mention that on far surveillance, on my phone, both my back and front cameras are always blacked out. I never have those available.
Yeah, I mean, with Palantir and all the cameras around and how the wireless can track you, I mean, we're surveilled 100% of the time.
I wanted
Unless
to
you're out
tell this story about when I was on a cruise ship recently. I met somebody. He was in a marketing company. He did marketing, something to do with marketing. And he explained to me, he said this is an ongoing practice right now. He said that there's companies that aggregate data and then they give them like a piece and then they can fill in the rest, like all your desires, trends, all that. But he said that one of the ways they're collecting that data now, I mean, this sounds like super Orwellian, but this is what he told me. He said that there are some televisions, not all of them, but some of the newer ones. What they do is they have a camera on the television, and then when it's displaying ads, the camera is using AI to watch you and determine whether or not you're interested in what's on. And then it takes that data and gives like a feedback. So he says that's already happening.
Absolutely.
But like with television, that's the only information I got from him. I don't know the details of it or how widespread it is, but it seems like they could be using that anywhere. Like as you're scrolling Facebook, it might do it.
If you are anywhere where there is cell towers, assume you are being completely surveilled. Your body language, your facial expressions, your haptics, the things you are saying, you are being surveilled. Just assume that that's the case.
I've come to that same position that you can't hide from it. So I think like the only logical thing to do is like embrace the truth about what you're doing, who you are, stand on it. And then like you're saying, the legal system is set up the way it is. That's the route. That's the amicable route.
Exactly. We're not. Yeah. So the Declaration of Independence says that when the government becomes destructive to those means, and those means, if you take that, there's a whole entire paragraph.
Those are the laws of nature.
Exactly. So when the government becomes destructive to the unalienable rights that are codified in the Constitution itself as the first 10 amendments to the Constitution, you need to be able to document it. You need to have prima facie evidence. Well, that is the standing on which you have to make a claim on which relief can be granted. And so do we have evidence? I interpret
it at like a deeper level than the Constitution. I think that the Constitution was a codification of facets of the laws of nature. And the laws of nature is this body of law that it's detailed, but there was a historical shift to move away from it, which is almost to say that it's like an admission that the government has gone corrupt. Within the body of the laws of nature, it says that if they ignore these certain tenets of the laws of nature, the invariable effect is the degradation of living conditions of the society.
Right.
So
and you have the right as one of we the
prosperity.
People. You have the right as one of we the people to alter or abolish it. So what we're going to do is we're going to make those claims. We're going to publish them on the public record. We're going to ask for rebuttal. We're going to define the laws of nature, which the Constitution is interesting because, and you are absolutely right in your assessment of the deeper laws of nature. That's exactly what it is. And that's the reason why those laws for human rights are unalienable. You cannot contract them away, even if you wanted to. And the reason why that's the case is because the Constitution is merely a box, defines a box that the government shall not operate outside of. Right to keep and bear arms, right to free speech, right to petition the government for redress of grievances, right to freedom of religion, right to, you cannot be held accountable for an infamous or otherwise capital crime unless indictment by a grand jury. Like these are the rules that exist inside of this system of self-governments that is a reflection of what the government shall not do in order to preserve the natural rights of we the people, the sovereign in this country. And you're absolutely right that's the philosophy that is lost. And the way that it was lost is through this slow progression over time of usurpation of the federal government assuming the role of the sovereign in the trust arrangement that the Declaration of Independence the codicil of the trust that declaration creates, which is the Constitution and the Bill of Rights. And by codicil, I mean it's the indenture, right? And so the public servants are supposed to act as trustees. They're the ones that are supposed to defend and hold the Constitution. And the Constitution is a codification of what government shall not do in order to defend and preserve those unalienable human rights associated with the freedom documents. And so that tenet right there, that philosophy, is exactly what this process that I'm going through is attempting to teach our public servants. Because, what's the old adage? Sometimes you can't show them, or you can't tell the people. Sometimes you have to show them. Like with the advent of the Prussian system of public schools, government indoctrination schools don't produce thinkers and free men and women. They produce servants. They produce factory workers and mindless drones. It's an indoctrination, and it's modeled exactly after the Bolshevik Prussian system. And so, these government schools are not going to teach us civically the things that we need as a free people to get out from underneath the system of control. And I would venture a guess that pretty much everybody that's in the room that I'm talking to right now was subject to MAPS testing and all the standardized testing where it's multiple choice. Well, those weren't to measure your ability to know what college to go to. That was a sorting mechanism, is what that was. And the free independent thinkers get sorted out of society because they're a disruption to the whole system, the Rockefeller system of control that was implemented about the same time as the Federal Reserve. And so the rabbit hole goes deep. There's no doubt about it. But the crux of all of what I'm saying is the fact that the contract law in which the system utilizes in order to hold the individual, the flesh and blood sovereign, to their statute, code, and regulation is all based on unilateral contracts and the fraud that they don't disclose that this is a corporation. It's an ens legis. It's a transmitting utility. It's not you that court has the jurisdiction to hear. And that's what the trust is going to do to right these wrongs. And, and as far as surveillance and all that kind of stuff goes, I'm not so sure that we're ever getting away from that. I think that to try and take on that machine would probably be a battle that is not one that you're going to win by, fighting it from the bottom up, so to speak. I think that, that 20 years from now, like let's say that this endeavor that we're all talking about here gains traction, and 10 years from now, we actually end up propping the republic up in a few states. I think that that there could be some sort of a litigation at that point. You need evidence that it exists first, but some sort of a litigation by the republic on behalf of the citizens to create, places where that type of activity without a warrant, you go to jail for as a public opinion. If we find out that you're being surveilled and your privacy is being invaded, contrary to the Fourth Amendment, that without standing and through this backhanded, some government agency said, "Oh, I don't like that guy's politics. We need to surveil him. You find me the man, I'll find you the crime." That's like the protections against that are already codified into the Constitution in the Fourth and Fifth Amendment. And so, I'm a firm believer that, once you actually read and study what's in that document, everything that we need to live the way we want to hurt no one, and to live our own way on private property and choose how much we want to engage or not, with the corporations, is something that has been taken from us. And the way in which I want to start this is going to lay the foundation and the groundwork to really have the standing and the jurisdiction to keep government out of private property at a certain point. And, they're going to fight against it, obviously, right? They don't want that. They want power. The one thing that a tyrant fears losing the most is the power that gave them the ability to become a tyrant to begin with. And, so that's why it was really important for me to go witness how these public officials and these judges and prosecutors operate inside of their system of fraud, because I needed to make sure, know thy enemy, right? And I needed to make sure that I understood them. And now that I think I do, or at least I have a starting point now, I can now craft the indenture of this trust that is a stepping stone to propping the republic back up and getting the de jure constitutional, assembly in each republic back up and running. Like that's another thing too, is that The federal government was never meant to be this involved in people's personal lives. They're there to regulate commerce. That's it. And as far as the local laws of the municipality and the state is supposed to be there. The republic is supposed to be there to keep the local municipalities in line. Because the local municipalities were always meant to be run as corporations, or at least in that capacity. Like it's a perfect way. I don't, like there's all this talk among lots of freedom to eliminate, the corporate entity. And I'm like, why would you want to do that? It gives you all the power through the maxims of contract law, because as the sovereign, you created that entity to begin with. You control it. It has no standing to compel you to perform to anything that you don't want to be subject to, as long as you didn't hurt anybody. Now, if you signed up for unemployment and knew that you were going to have to be subject to the code, regulation, statute because you wanted company corporate script because, that's where you're at, well, okay. I mean, at least you know what you're getting into, right? It's not that hard to get your car registered and turn your blinker on and not use a cell phone when you're driving. I mean, it's really not that hard. But when we're getting into the stuff that we're getting into now, where people's liberty are being taken them without being charged, right? I mean, we've crossed the line. We've absolutely crossed the line, in my opinion. And so that is what, I think that this entity could really be the trust that I'm talking about creating, could really be, the not the end all be all, but it could definitely embody, the knowledge and the ability that one needs to have in order to maneuver inside this system to hold our public servants accountable and restore this constitutional order. Going back to alter or abolish it, my philosophy on this is that I don't want to alter or abolish the federal government or the state government or the municipal government for anybody but me. I have no standing to tell anybody else what they should agree to or not. It's not my place. That's the whole point of a constitutional republic. So I'm not saying that the corporate municipal policy enforcers can't exist. It's there. They exist by charter. They actually do have a right to exist. I don't want to abolish them. I don't want them to no longer have the capacity to pull over, some immigrant that has been given a CDL without any training, without any expertise, and shoved in a death machine that a fully loaded semi is in the hands of someone who doesn't know what they're doing. It has nothing to do with their immigrant status, right? I mean, I want those individuals to be able to go police that, because that's a violation of public safety. That's inherent negligence. And, so I don't want a Wild West situation where everybody's just, dueling and killing each other. That's not my idea of a peaceful society. But, this surveillance thing that just brought up and the way in which it's implemented, there needs to be some boundaries. And private property is that boundary. And not to say that they aren't going to illegally surveil you. I'm sure that they will. But what these protections do is anything that's charged against you by information or admission of guilt or any, evidence that they might think that they have that's obtained through this illegal process, in fact, not only is it not admissible in any court, they're going to get fined. They're going to be pursued by the trust for their violations of the box that the Constitution is supposed to put them in. And will this create situations where people with malintent are going to be able to get away with things that are going to hurt people? Yeah, that's exactly what it's going to create. And unfortunately, that's the evil world that we live in. And the existence of evil does not, in my opinion, justify the usurpations of God-given rights. We've all got death coming at least once. And anybody that's so afraid of evil and something bad physically happening to them in this world, well, in my opinion, that individual needs to really get right with God, because they are living for the wrong reasons to begin with. And to violate these God-given, created, granted human rights of right to liberty and justice and privacy and all the rest of the things that are codified in the Constitution, to usurp those in the name of public safety. Man, we've been down that road as a civilization lots of times, and it always ends in death and like millions of horrific deaths. It always does, every single time. And, but the bottom line is, regardless of whether or not an individual in power agrees with that or not, it doesn't matter, because the Constitution is clear, and we've got the ability with this process and with this standing to hold them accountable and stop that. And so, the ability for the public servants to gather information against you and use it against you in a court of law stops at your private property unless you agree to it. That's the way it works. And if they don't like it, they can go get a warrant.
Sure. Cody, I got a couple of things about the website. For one, I'd like to suggest we have a glossary of terms incorporated, that way everybody has the understanding.
Absolutely. That's a good idea.
Yeah. And also, AI can make websites. Would you be opposed to AI making a website?
I wouldn't be opposed to it. It's just that I'm more than a little skeptical of the terms and conditions on the companies that provide those services. Any AI is, there's a hidden agenda there with AI, and it all has to, all you have to do is look at the corporations that are backed by Vanguard, State Street, and BlackRock, and look at the investors and look at the campaign contributions, and then look also at the board members, and then their family members that are appointed to these companies that are creating these platforms that provide these services. And when you dig into the terms and conditions, you end up with a pretty real awareness of how inculcated the control and surveillance system is in almost everything. And so I'm not opposed to AI. I just think that needs to be said in order to comprehend that, hey, expect that there are going to be contractual ties back to this website, that if you use those services, even a web hosting service, right? Like, there's going to be the same thing. You can't have a conduit into the system that is of control, that is the matrix, without getting that tacit agreement, contractual obligations associated with the actions you take inside that matrix. And so that's the reason why it's so important, in my opinion, to do everything in the matrix from a trust. Put that firewall of protection between you and the matrix itself in any of the commercial dealings with terms and services and anything, any subscription to, anything online. You do it through the trust, and that is your ants legis, right? Like, that's the entity that we go ahead and give them access to. It's theirs to begin with. They created it. It's not ours. We just use it to settle the debts because they confiscated all of our lawful money in the private, and we use it against them. We use their fraud against them in that arena to just, like Ken was talking about, the rice trip.
On the website, a suggestion is you can have AI make the website, then you can emulate it into another organic website. Just use their...
Yeah, that would work. Yeah, just have them produce something and then copy it and shift it over to something else. That's fine. But I don't think that you're going to get away from the thing that I was talking about by doing that, because you're still using a web hosting service. You're still having, an IP address. You're still having to, cite your country of origin, which is only the United States. They don't have the constitutional republic in there. And so, I guess what I'm getting at is that, there's things that are in there that I see, that just be aware that there's no way to get away from, having the federal government and the state government have a hand and a vector of attack, if you will, to mess with your business online. And the reason why that is because there's just no way around it, whether AI produces it or not. And so that's what I was getting at. That's the reason why I'm not opposed to AI. I just wanted to state that so that everyone was aware of it, to know that, when you're using these online services, and Zoom, for instance, Steve, you got a freaking tracking device on your car. Guarantee you that the recording that we're making here and the things that are being said, if they're not being actively listened to right now, they're going to be. AI is listening to it, and it's going to be flagged, and some special agent's going to listen, to parts of it, because we're under surveillance.
Hello, FBI.
Yeah. Hi, guys. Hey, you glow bastards. Leave us alone. It's better for everyone. We just want you to leave us alone. We're not hurting anybody, and we never will.
All right.
Not unless you come for us first. Right to defense.
Well, glad you're with us, and we're just looking forward to having this thing develop. So.
Yep, it's exciting. Yep, this has been a long time coming, and I knew that I kind of described it a while ago about how I knew that there was a solution like this, but I didn't have enough picture of who and what I was dealing with in order to really build it. But now I've got that awareness and that knowledge, and so it's yeah, and there will be a ability for the board of trustees in this entity to, amend the codification, to pivot. I mean, you can't think of everything, and so it will not be constricting from my own vision at this point. By the time this thing is done, it might look completely different, and that's fine, but there will be a provision in there that it's subject to review, as long as the changes in the indenture, this trust indenture, adhere with the overall mission of a peaceful remedy using the maxims of commercial contract law, constitutional jurisdictions defined in the Constitution itself. I mean, the rule of law as it exists. And so if some part of the indenture, if my comprehension of it is flawed at this point, and I gain new information later, that the trust is operating in a dishonorable way because I lack the knowledge to create it in an honorable way at the time that I created it. Well, we're going to have a mechanism in there to, if we've harmed anyone, we're going to make them whole. That's the number one thing. If we've caused damage to anyone, there's going to be a remedy process that, yeah, we are in the business of making those that we harm whole. Absolutely. And there's no way to stand in honor without that. And you can't get to the remedy that we're looking for without standing in honor with clean hands. And so that'll be built into the mission statement. And so that's the vision there. But
All right, Cody, we appreciate you being a force in the freedom movement.
Well, I'm glad that I can contribute on the level that I can. It's exciting. I've been looking for a way to to provide remedy. I mean, this the scope and the breadth of the information that I've absorbed in the last 5 years is not something that is feasible for the numbers of people that we need to prop the republic back up, according to the Articles of Confederation. Like, it's not feasible to have that happen, and in our lifetimes, and so this is the vector through which to accomplish that, in my opinion. Put it in a trust. It's what the founding fathers did. So
yeah, emulate what was successful in the past.
Yeah, and the beauty of it is that the battle's already been fought, the blood's already been shed, the treaties have already been signed. It's the power and the authority is already there. All we have to do is learn how to wield it.
Yeah, we honor their sacrifices.
Exactly. Yep. That's why it's so important for me to do this with clean hands and to try not to hurt anybody. So, I mean, the bloodshed's already happened. The bill's already been paid. We got to try and do this in a peaceful way. We have to.
That's my confirmed intention. Honor their sacrifice. They gave their lives, their fortunes.
I like that. Yeah, they committed their lives, their fortunes, and their sacred honor. And a lot of them lost all of that to give us this opportunity. And I'm with you 100%. I want to honor their sacrifice. Yep. And I believe I'm with you. The way that we do that is we follow the rules that they gave us, and we do it right, regardless of what our adversary does. We don't sink to their level. We do it right.
Amen. That's right.
Amen.
Appreciate it. Well, is there anything else? Or?
I just wanted to know, Steve, when your hearing is, because I want to try and have this this trust indenture done, and at least have it standing finalized. And so that'll take a public meeting announcement.
Okay, on the second day of this month, I don't know if you're aware, they pulled me over for a private license and threw me to jail. I was in jail for 5 days till I was able to get bonded out. But in the process of being bonded out, we had to pay off some outstanding warrants. So all those are tentatively resolved unless I reopen the thing. The only trial I have is the end of February, which is a speeding and no registration ticket. But everything else has been resolved, as far as they're concerned.
Okay. All right. So those. Okay. All right. So the one thing that might have been different, if I, in that situation, I'm glad that's resolved. That's good to hear. That's the best way to deal with things, in my opinion. When
not to my satisfaction.
I understand, and we might be able to get you some remedy to that after we get this legwork done. I'm reluctant to open up old battles because there's enough battles in front of us. But if it's something that would benefit the furthering of the mission statement of the trust, then that would absolutely fall underneath its authority to present the interest of on the behalf. And the reason why I say that is because that's what's going to need to happen in order for the trustee of the trust, or one of the trustees, that like I would be a trustee of the trust, to come and be your next friend counsel with a controversy that you have with your elected public officials or your public servants. And so if that is resolved, then there is no more controversy, and then I, as the trustee, would have no standing to make a claim on which relief could be granted on your behalf. So that's the reason why we would need to have some sort of cause of action, to bring up an old thing, which I don't know if we did, if it would be in the benefit of furthering, the interests of the mission of the trust, which is to educate our public servants about constitutional rights and how they're violating them on the daily with the things that they do to us. And so, but yeah, I'll get I've got it already roughly worked out. And once I have these further interactions with my local venue, citing the things that I'm going to cite about Article 1, Section 10, the lack of ability to pay any debt at law, and do the filings that I'm going to do and see where they take it, I'll have a lot more knowledge that I need to be able to articulate clearly and concisely in the indenture of the trust and what the trust is authorized to do on behalf of its beneficiaries in those instances. And so because the trust is going to be standing exclusively on the constitutional common law jurisdiction to present the interests of its beneficiaries to its public servants when those oath of offices are violated, the indenture is very important with its construction and the wording and the terms that it uses, and the reference of the authority that it uses to have authority to make the claims that it's going to make against the public servants. That verbiage is very important. That will be the key, if you will, if the key fits the lock, as an analogy to whether or not the trust is going to be able to gain remedy on behalf of its beneficiaries. And so, it's I want to make sure that the language is strong and perfected before we implement this, so that the first couple times we use it, it's got a high rate and chance of success to obtaining remedy, which will be defined in the trust itself as being left alone. And so anyhow, but so I'll get that taken care of, and then I think that it probably would be a good idea. Maybe anybody that's interested in joining me in the organization and the administration of organizing this entity. Like I say, we're going to need to put out public notices, so that would be in the paper of the counties where you guys live, and then a couple of affidavits that we need to create based on the individuals that are going to call to order this organizational meeting to create this trust. And then, we'll need to publish that in the public record, and we'll need to keep the newspaper. We'll need to post it like at the library. We'll need to ask for anyone in opposition to come to the organizational meeting or write the administrator with their concerns and any notices that they have about why we shouldn't do this, or if we don't have the lawful standing to do this. Otherwise, silence is acquiescence. And after this date, the matter is closed. And anybody that doesn't come up with any reason why we shouldn't do this, this is your window. And if you try to bring something after the fact, it's too late. And so anyways, we'll need to write that and then publish those things in the paper, send the notices to the Secretary of State, Attorney General, the governor, the commissioner of safety, the police chief in your county, the sheriff in your county, all the individuals that represent the body politic of the government, our public officials who might have objection to this. We need to notice them, give them a time frame, invite them to the organizational meeting if they would like to be there present to contribute in any way. If they have anything to be heard to the administrative capacity, the individuals that are going to create this, then, we want to hear them. We want them to have a voice. And so we can ignore them with impunity uh, and do what we're going to do anyways. But at least we gave them the opportunity to speak and object if they so choose. And so what that'll do is that will create the authority and the standing of the entity to have a recognition at law in their jurisdiction in the capacity that the trust is meant to do, is to present the interests of the executors of all these express trusts. That is the entity that they can deal with. And so we'll call it out right in the organizational information. And but anybody that wants to participate in that, why don't we go ahead and stick around, and we'll come up with a time and a place where we can meet again and get that going.
Hey, Cody, it says, you mentioned about opening up old battles. How that can benefit the trust is extracting the funds out of the bonds. That's something I'm looking at. That way the trust is benefited in that matter.
We will absolutely explore that option, and I will keep that in mind when I'm writing the indenture. Something that comes to mind is a provision like, should the trust choose to, initiate a settled matter in order to obtain operating funds both for the member, the beneficiary, and the trust through donation, then, that is something that the trustee and the beneficiary can choose to do at their discretion, something like that.
In those bonds, there's millions of dollars available. So it's just
well, but the thing about that is that, it's still just corporate company script, right? It's still just slave script is all it is. And the PMA that I'm going to send through the mail, that I'm not ever going to put in an electronic format, because that's not the jurisdiction that it exists in. It's never been sent electronically. I typed it on an electric typewriter, and I've handed it to a couple of people in person, copies of it. But I'm going to send you guys down a copy of that, and so the financial system that this PMA is a piece of is derived on the same premise that the financial system that they use against us is also derived on, which is the value of the promise to pay of the creditor of you, the living man or woman. That's where all of the value of the financial system comes from, is promissory notes. Congress can originate those by borrowing money, right? They create a promissory note because they have the purse strings. But it still goes back to a promissory note to the Treasury. They create a Treasury bond on the full faith and credit of the United States, the corporation, which is then exchanged dollar for dollar under HGR 192 for Federal Reserve notes at the currency, at the discount window, the comptroller of the currency. And so, we already have the ability to create an infinite amount of credit in their system. And in my opinion, the only time, if we're going to be standing in clean hands and honor, that we should do that is when we need to extinguish a fictitious or an erroneous debt that they charge against the entity just to try to hold you debtor and surety to, in order to hold your private, personal, biological information and surety to those debts. I know there's a lot of money in there, but it's really only currency. And the ability for that money to discharge a debt is the exact same as a bag of rice. So, give unto Caesar that which is Caesar's. And I'm a firm believer that, that we don't need a lot of their Federal Reserve slave script, to accomplish this. The compensation for the individuals, like the only reason why I really put that provision in there is that I envision this trust that this vision that I have to create this entity to prop up the republic, by showing people what we can do with the right information in their venue, and give victories to the people that are being oppressed by getting officialdom to leave them the hell alone. Like, we can accomplish that for people, then I think that, the financial needs of this trust are going to be more than taken care of, because it really doesn't take much, to keep a website going and to disseminate information in this electronic age. And then the individuals themselves, let's say that at a certain point, we need, 10 or 15 trustees running around presenting the interests in propria personam, with the beneficiary in the courtroom, which is what I envision happening sooner or later. The trust, I'm sure, will gain many donations whether, regardless, we can access the financial value in the form of Federal Reserve notes from these bonds in their venue. I think that the remedy that we seek, which is to be left alone, that victory is going to be able to be obtained very easily. And imagine the prosperity that one could attain if you show up and go to work and get an honest day's wage, and you can turn around and not be taxed on it and keep what you earn and turn around and put that into property and equipment. And pretty soon, there's a group of like-minded individuals that are relying on the PMA to transact their business among one another. And Federal Reserve notes are fairly easy to get a hold of, by showing up and doing some stuff. And I mean, how much do you really need? If you have private property that is not taxable, where you can grow your own food and raise your own animals, build your house the way that you want it to, and the federal government, as long as you're transacting with your neighbors with your excess that you produce outside of their system, they have no jurisdiction to even question what you're doing. They don't even get to come up. I mean, if you can have a notice on your property, at your private property, that anybody that comes up that is uninvited, that is presenting the interests of the corporate municipality, you're trespassing, and trespassers will be shot. Call with a warrant, and I'll come to you every time. Sure. If you have a warrant, we automatically say that we will come down to the sheriff's station, we will come down to the police station, and we will come unarmed, and we will engage in due process peacefully every single time. Get a warrant, and we'll play ball. Okay. Other than that, we don't answer questions, and you're trespassing, and this is your last warning. Leave.
Okay. Earlier I said it was earlier this month that I was arrested, but now I think about it, it was exactly a month ago to today. So that was last month. Anyway, I got a question. You mentioned you have a PMA and a trust. Would they need to be recorded? Because I talked to somebody about having a trust recorded. They said only you need a certificate of the trust recorded.
You can record it if you want it to be judicially noticed in their venue. And the whole thing about this PMA, the reason why I'm keeping it completely off any electronic dissemination format is because it's none of their business. I don't want them to know what's in it. And so, I would say that, depending on what your goal is with the trust, do you want to interact with your corporate municipal employees with this trust? Well, it's probably a good idea to get it recorded, because then you can record a schedule of fees associated with violation of the indenture. You can preemptively name your public servants trustees. You can record a schedule of fees, and you can have a box of tools to apply leverage to offending individuals that break the oath of office. And then now you can have this way that they have to judicially notice that entity, that documentation, when you file it into one of their cases. If it's recorded on the public record, they can't ignore it. And so it really just depends. And so that is an accurate statement, that sometimes you don't need it recorded. And so like my Express Trust, I've put it into their venue as evidence, as an exhibit, which is the standing on which I'm claiming the executor status to the defendant that they have listed in their charging documents. And so, it's out there in their realm now. And so, but there's nothing in there that I don't want them to know anyways. In fact, I want them to know what's in there, because I want them to know that unless they can rebut that, if that's not my standing and jurisdiction and authority to claim, well, then they need to make that assessment. And I'm all ears. Like, if there's something that I don't know about, I would invite them to do that, because that means I will completely surrender that instantly just to them. They can keep it. Leave me out of it. Don't send me anything associated with your charges to that defendant, because it has got nothing to do with me if they choose that I'm not the executor of that account. I could be happy. I would love that if that was the case. Remove the vector for them to even talk to me, the living man. In fact, I've got documentation that I was given that I tweaked a little bit. It's called an ecclesiastical deed poll. You use that in conjunction with the claim of the title under the Minnesota Rule 220 to claim the title to the biological property, which is the birth certificate, not the certification of live birth, but the birth certificate itself. We use this ecclesiastical deed poll to either agree to issue a ruling that says that the government agrees that I am the allodial title holder to that biological property. this. And without a constitutional due process to remove my life, liberty, and pursuit of happiness, they can't talk to me. They can't take me into custody, not unless I've been convicted. And through the process, which I agree to preemptively. I agree to these rules. That's the subject status that I agree to in order to wield this authority. And so if they wanted to then say that, no, you're not entitled to be the executor, I'd be like, well, what am I entitled to be then in relationship to this account as the living man, the creator of government, the grantor, contributing beneficiary to the Constitution? Your Honor, define what my relationship to this is. Well, you have to be the surety. No, I don't. Produce the wedding maritime signature contract that says that I agree to that. I don't have to accept those benefits. I don't consent. Hale versus Henkel, Marbury versus Madison. Settled matter. Keep it. In fact, dissolve it. You got it. If you don't want me to be executor, I rescind executor status. I remove all claim to any value in anything associated, benefits or otherwise, with that ens legis, and you keep it and leave me out of it. I prefer that arrangement. Don't call me ever again. Take it. I quit. Dissolve it even. And, and provide to me the evidence that these records have been destroyed. It doesn't exist anymore. And you guys keep every value, penny associated. Keep it all. I don't want any of it. I rescind all my claim. I don't want your slave script. I want my liberty. So that's my stance on that whole thing.
Appreciate it. I'm fixing to read the scriptures. Would you be willing to stick around?
Please. That sounds fantastic.
Okay, let me do that real quick.
What's the bigger things?
I got to. Huh?
Let me turn it on.
Yeah, I'm gonna turn it off.
Well, also the sticker box, so we can hear it.
I guess before we do that, that's kind of a final thing. Has anybody else got anything else they want to talk about?
No. When would you want to get together for the next meeting to see who can do what?
Who there wants to be involved, and let's just talk about it and pick a time that works for everybody.
Okay.
Set it up right now.
Darren and Steve. Sherry wants to do it. Anybody else?
Let's somebody throw out a time and a day that works. And I'm on my own schedule, so I can be there. But you guys, I don't know what obligations you guys have, so let's just start throwing out times and dates. And if it doesn't work for you, suggest something else until something comes up that works.
We could do it 2 weeks from today. I've got somebody speaking next Tuesday, but
You need it sooner?
2 weeks from today definitely works. I will definitely have the time to gather the information that I need with what I need to do, and then have the time to codify that into the indenture, and then I can have time to distribute that to you guys. You can read it, and that way we're kind of all on the same page before we start. We could talk about, the philosophy of it a little bit, if there's anything that doesn't work for somebody, and, to update it before we really get serious. But I think that the major agenda of the next time we talk about it would be to come up with what is going to be published in the public record, in the newspaper, and where, and then come up with task committees for individuals to take those documents that we create collectively, and then, define where they're going to be published and what the process is to accomplish that. And then, pick a date and a time for that to be concluded, and then reconvene afterwards. And I'm sure that we'll end up having pushback and, they wouldn't print it. And anyway, so that, we're gonna have to deal with issues as they come up with solutions based on the problems that were presented as we attempt to do this. So I think 2 weeks is a good time. And I'll have the indenture distributed. Go ahead.
Give me some time to get more people.
Perfect.
Because we're kind of working from a private meeting. We're not. I'm not inviting that many people these days until things, get better understood what's going on.
Honestly, I understand that. And so when I was with Kids First here in town, one of the first organizational meetings that I had, an individual who was a local political personality who was on the local assembly as a liberal showed up and recorded the entire thing. And there was a bunch of individuals who were very, very fearful of government that were like, oh, you got to kick her out. She's recording you. I'm like, I don't care. We're being recorded anyways. And whether good. And I looked right at her and I said, take this to all your cronies. I will not say anything here in this meeting that I will not say in front of a judge. What's happening in this society is egregious and it's awful. And I intend to utilize my First Amendment rights, freedom of speech, freedom of assembly, to try and come up with a plan to take our parental rights back and get these tyrants in these offices that think that they're in charge of everything to start honoring the social contract that we're supposed to have in this country, where the parents are in charge of their kids' medical decisions and people are in charge of and responsible for their own behaviors, and not the government. And I was like, and so like, go ahead, record me. In fact, put it on every newscast you can. I mean, so I'm a firm believer that, we need to operate with the assumption that the feds and the judges and the cops, like, invite them, let them know what we're doing. Because I honestly would rather them be privy to what we're doing, because in my opinion, the status, standing, and jurisdiction that we're coming from, and the fact that we are attempting to utilize First, Fourth, and Fifth Amendment rights in order to come up with a remedy for grievances that are happening to us personally, that are clearly in violation of oaths of office. And we're talking about, amnesty and forgiveness if they change their ways, and openly stating that we don't want anybody to go to jail. We don't want to hurt anybody. Bring it. Let them listen. I mean, and I understand that there's interlopers and people that are going to attempt to undermine. But I mean, what are they going to do? They're going to leak the information that we're a bunch of God-fearing patriots that want to learn the constitutional process and offer forgiveness to the people that have hurt us and taken our liberty and taken our resources and are violating the trust that's created by the Constitution itself. And we want to give them an opportunity to repent and be forgiven, and then remedy the situation, not only for us, but other patriots that come after us. I'm willing to take that gamble that that gets out.
There's a type of action that I'm aware of. I don't know it off the top of my head. There's a name for it. It's based on a case decision, and it's named after the guy who brought it. Bivens. But it's a type of like a remedy you can seek when not for like constitutional violations as an individual, but it's when like the government has like a pattern and practice of it. So maybe that's something that we could explore after you build this traction and awareness through the notices. Then you seek the court to like order the remedy. What are they going to do about it? I mean, you could frame a proposed remedy for it.
Yeah, so that is that's the Bivens remedy, and so that was Supreme Court case precedent. Bivens versus 6 unnamed United States agents, and what that did is it codified a remedy for an individual to claim under Title 42, which is civil liability in the personal capacity. The liability transfers then to the federal government for the actions of the individual who is operating in their official capacity when the violation was committed. And it's interesting, I actually have a suit that I haven't filed yet, but that I have attempted to obtain remedy with the Coast Guard, where I was detained for almost an hour, a little over an hour, for a safety check on my boat, which was, I called it my private property because at the time I was not engaged in commerce. And the boat has registration markings on it, AK numbers, and I have a captain's license, or like the NSLE just does. And so anyway, I can actually leave a link here, but that entire encounter I recorded. And the very first thing that I told them is I asked them a question, is whether or not the federal corporation, as defined in 15 USC 3002 15A, 28 USC 15, I forget the number, but it's codified in Title 28, 3002 15A. That's where it is. 15 is, Title 15 is debt collection. But anyways, the government is defined as a federal corporation, right, in their own bylaws in Title 28. And so I defined that to these guys and asked them if they were presenting the interests of the federal corporation or if they were there presenting the interest of the de jure republic. Because I asked them, do you have any evidence that I am engaged in commerce? Of course they didn't, and I wasn't going to give them any. And I wasn't. And so therefore, in my opinion, they did not have my permission to impede my travel because they didn't have any reason to talk to me. I asked them if they had a lawful warrant. They said no on video. I asked them if they suspect me of disturbing the peace. No. I asked them if they suspect me of committing a felony. No. I asked them if it was a criminal investigation. No. Well, then I don't answer questions, boys. Why are you talking to me? Leave me alone. I'm traveling and in my private property, and I'm on my own business. Leave me alone. And they didn't. And so I informed them that I wasn't a threat, that I was not combative, and that I just wanted to ask questions about jurisdiction and their authority to engage in the statutory search that they were claiming I was subject to. And if they could produce the evidence that there was an enacting clause to their authority under the title and the code that they were citing under the federal authority of the federal corporation, that I would comply. They couldn't provide that, but they stayed and they messed with me and they messed with me. And so that is a very good, I'll post it, or I'll send the link to Ken, and Ken, maybe you can, or Darren or somebody, maybe you can proliferate out, or maybe I'll send it to everybody that's on the Zoom link here, the link to this video on Rumble. And so that interaction really defines what you need to do, in my opinion, in order to have a claim on which relief could be granted in order to claim a Bivens suit. But you need to first establish an administrative remedy underneath their own provisions to send a claim to the secretary of the organization that whose individuals violated your civil rights. And it's actually under the 14th Amendment. But it's an assumption that under the 14th Amendment, the Enceladus has rights to all the first 10 Bill of Rights, and which is something that isn't always the case. And so I'm reluctant to utilize that Bivens remedy on behalf of the Enceladus because it is a remedy for a U.S. citizen and not for a state national.
Right. They're using the 14th Amendment. We stay away from that.
I think it's best to stay away from the 14th Amendment. And the reason why that is because the entirety of the government, Congress, is a creation of the executive branch of government under Executive Order Number 1, issued under emergency martial law powers by Lincoln. And he was assassinated before he could dissolve that body politic. And so if you accept the benefit of the right to make a claim underneath that remedy process codified in their jurisdiction, I believe that you're accepting tacit agreement to be subject to the U.S. citizen status. And then all of a sudden, code regulation is, again,
I'm not sure the name. You're saying Bivens was the name of it. I think what you're
USC 1983
putting is like vicarious liability of the federal government on behalf of individual actors. That seems like what you're describing. I was describing something that is more like a remedy that it seeks to like put an injunction, not so much like monetary compensation, but it's to remedy like an ongoing practice, like if they've codified it into law that's what they're going to do, and
if you could come up with that name, if you could come up with that name, I would very much like to. Excuse me, caught up with me there. I would like to read that because I'm not aware. If it's not the Bivens remedy, then I'm not aware of what you're speaking of, and I want to be. So that's definitely something that I want to be aware of.
I wish I took notes. I don't take a lot of notes. I just
no worries. I know that the process through which you're describing seems awful similar to the process that I used to create a claim on which relief could be granted with the Coast Guard by administering a administrative remedy process based on an affidavit of truth and fact, and then citing, the case precedent about how affidavits are, sovereign in commerce, and an unrebutted affidavit is judgment in commerce, and, all the maxims of commercial contract law that are associated with an affidavit of truth and fact, and sent that to the Coast Guard here in Juneau as an administrative remedy process under the First Amendment right to petition the government for redress of grievances. And so I stated all the claims on which I felt I was aggrieved by describing their actions, what I was said, referencing the video, and then, made the claim that this is a violation of the Fourth Amendment. They had no lawful warrant. They had no reason, and they forced their code upon me to be subject to a safety search, which was an illegal search and seizure under the Constitution. And, if I'm wrong, then rebut this and I'll drop the claim. But they didn't rebut, so that means the claim is in full force and effect. So what I then had to do was go and send the invoice to the JAG and commandant to the Air Force General and some officer in this precinct. And lo and behold, shortly after I did that, they changed their internal policy on how to obtain remedy for redress of grievances. So it's an interesting concept that you bring up, but I actually went through a process that already exists according to the maxims of commercial contract law, the Clearfield Doctrine that defines that the governments or municipalities, corporations, when they violate their oaths, they devolve to that of a regular corporation themselves in lieu of qualified immunity and immunity from suit against, because it's no longer the U.S. citizen that's claiming a grievance, it's the creator, the grantor of their authority to exist to begin with, and you come in through a superior status to make that claim as the grantor and the contributing beneficiary to that constitution that supposed to hold government in the box, which they shall not operate out of, which they do all the time. So you define that, and then I did an article 2 of that affidavit, that undisputable facts, status, standing, and jurisdiction, which defined all of this, referencing all my affidavits that are cured on the public record for them to go reference and to have a venue, if you will, that created its own court of record for the controversy. And the only thing left to do for me now that we've passed the administrative remedy process is to state a claim with the Secretary of, which I did, Secretary of Department of Homeland Security, the Commandant of the United States, the Attorney General for the United States of America, and the CEO. I noticed all of them that this secretary in this office was not adhering to their obligations. And so the next step is to file a commercial lien for $60 million on the local housing for the enlisted men here and take that over on behalf of the trust. And so, there might be corporate sponsorship here before too long anyways, but I need to get a few things in precedent in the local venue before I bite that off, because there's some national security implications if I can seize property that's on a military base. And so I'm researching some Title 50 stuff because, if all of a sudden, some podunk fisherman from Sitka can, have superior claim and title to the housing for all the enlisted men in here at a local Coast Guard base, and that is going to open up a whole can of worms that I might not want to be involved with, and we'll see what happens. But I think they know that I'm not going away, but I'm just focusing my efforts on these other battles first before I take on that situation. And so, if you could come up with that name and that case precedent, it would help me tremendously to have some standing. That the remedy that I'm seeking is a remedy that's already been utilized. And so anyway, but that's the way their system works. But yeah, so I'm all ears about that one.
I got a question. A couple of things you mentioned remind me of this podcast where he says when the judges are corrupt, you can call in the military JAG, the Marine Corps JAG. U.S.
Provost Marshal. Yep.
Okay.
You notice the U.S. Provost Marshal that you suspect the local administrative or Article 1 tribunal court of damaging your constitutionally protected rights in the private. And should they continue to infringe upon, by breach, the oath that they have to uphold that grants them their own authority, you're going to arrest them for treason, and you'd like them to be there to carry out the sentence.
Have you utilized that entity?
You already have it. You already have it as one of the sovereign we the people. So you just need to, call your enforcement division of the U.S. Provost Marshal at wherever your joint base is in your region, and let them know what you're planning on doing. Let them know what's happening. Give them the case numbers. Say, hey, these are the unrebutted affidavits that they've admitted that they did this, and I'm not getting remedy. I'm about ready to arrest the judge for treason. This is when the hearing is, and I'd like you to be there to enforce the arrest.
I'm going to proceed.
You have the right to citizen's arrest, absolutely. And if you just do it and you do it without standing, then that's a problem. But if you complete the administrative remedy process, then all of a sudden now you have standing to make a claim on which relief can be granted. And those, without them coming up with a reason why through a rebuttal that they're subject to Title 18 criminal code violations for usurping authority under 18 U.S.C. 241 and 242, you can just state that in the courtroom and say, if you're going to continue this and not give me remedy based on the truth and facts placed upon the document and upon the public record by my documents, then in my opinion, I don't see how that's not treason. And you would be subject to 18 U.S.C. the penalties in 18 U.S.C. 241 and 242. If you want to continue this, Judge, let's dance. I'll place you under arrest for treason. U.S. Provost Marshal's right here. Let's see what happens. Maybe they're going to take you away. Maybe they're going to take me away.
Okay, Cody, got another question. We have been debating whether we should start whistleblowing the IRS to the courts here because they're not disclosing the nature of the accused, and we're not able to see the various different bonds, the bid bond, performance bond,
Payment bond.
and payment bond. You think it's a good idea to fill out those forms and request the IRS to investigate along with the SEC? Would that be something that might be a wise decision?
Define your terms of victory before you start this battle. That's the first thing that I would recommend. And if you want to get into a pissing contest with the courts and the IRS over who owes who what, then that is a great way to do it. And if you want the IRS to leave you alone, I suggest that you buy a copy of the affidavits from my mentor that I bought from him when I first started all this. And I read them and researched them, understood them, comprehended them, became available to defend them. And then I fired them off. I sent them to where I needed to send them to. And it stopped an audit. I have not paid taxes since. They leave me alone. They don't investigate me. I don't get any letters. I don't get it. I mean, so, define your terms of victory. If you want to go into their jurisdiction and their venue and start trying to wield this power and throw it and get monetary compensation out of them, that is the exact method through which you would guarantee they come after you on offense, because I do believe that you could obtain a remedy that way if you're willing to fight it. I do believe you can, but what are you willing to pay and endure in order to get there? Is it worth it? And so
They'd have someone auditing you if you did that.
I'm sorry?
Well, there's a good chance you would get audited. Fairly?
Yeah, why not just tell them we're done here, leave me alone. Like leave your unapproved, non-positive law in Title 26 that all these slaves out here agree and sign their 1040s that they agree to be a taxpayer. I don't agree anymore. I already sent you guys the stuff that said it was fraud. You want to proliferate this? Then let's go. Like I'll take this to court. And we can go ahead and get all these affidavits that got all this stopped on the public record. I prefer you guys just leave me alone and I'll leave you alone. You keep running your scam on people that are dumb enough to fall for it, but you leave me out of it.
The problem with the forms, though, Cody, it asks if you're a taxpayer, and they're going to send you a reward for doing it. So you kind of hop back in the bed with IRS when you do it.
Yeah. That's the way they do it. I prefer to exert the jurisdictional boundaries and say, we're done here. I don't want give it back to Caesar. Take whatever you want. I don't want anything back. It's all slave script anyways.
But Cody, their intention is not to receive monetary gain, but to get people free, shake them up enough that will release some captors.
I have documents right now that I guarantee you will get the IRS, and any audit stopped. It will stop the IRS from collection attempts. It will stop garnishment. It will stop the IRS from even talking to you. You won't even have to pay income tax again. The HR department, the payroll department, depending on where you work, might have a little bit of a problem with trying to do this because they're compartmentalized legal idiots. But that would be one of the functions of the trust, is to present your interests as the executor to the entity that is tax exempt, and cite both the code, the precedent, and the law governing Title 26 and how it's not law at all, and then start hitting them with some code violations that if they continue to exert that you must give them a social security number and not an EIN in order to work there, then they're going to be sued. And I mean, so you use these things to your advantage to obtain the remedy that you're looking for, which is to be left alone. And if they choose to take it that far, absolutely, we'll sue them and we'll win. And you'll get money, and you'll get you'll get Federal Reserve notes. Hopefully you choose to give some of that to the trust so we can keep doing this work. But the goal, in my opinion, really needs to be to just say, I don't care what happened yesterday. We're done here. This is a toxic relationship. You guys are not doing what you're supposed to do, and I'm done here. I'm out. Leave me alone.
When I said freeing people, he's referring to people who are physically in custody right now.
Oh, what kind of people?
People who are physically in custody.
Okay.
The issue is when we do the whistleblower forms, it will keep them, it almost would force them to release the inmate because it freezes them up until they get their accounting straight to be able to continue doing business. That's what our mission is, but we don't know.
Do you have people that are incarcerated for tax liability?
No, they're just incarcerated, period. You're going after the county because they don't have accounting records and they should be able to give that to you. It's required by law.
What are they incarcerated for?
Well, it's just numerous things. I mean, some is, drugs, for example, one person, and another person, it's domestic dispute, things like that. They're not, there's no injured party, but, that's the way the system works. But we're just trying to get people that are innocent, and we're told that this will tie them up if we report them, because IRS will go over there and they'll freeze everything where they can't keep doing business. That's what we're told will happen.
I would be very careful with that. I would have to know more of the ins and outs, and I would have to read the documents that accomplish this to be able to speak to what I think the liabilities may be moving forward. If it's a strategy to protect assets of an individual that's incarcerated, the way to do that is to organize your assets in a way where they're not tied to your name to begin with. And that is, assets are a vector of attack, especially when they're held in trust by the municipal corporation. There's no doubt about it. I think that you could accomplish the same thing with the documentation that I'm talking about. And the other thing that could happen with the documentation that I'm talking about is those individuals, we could get a hold of them and have them sign in front of a witness these other documents that I have that I also got from my mentor that create the standing to challenge all of these unlawful incarcerations that were no administrative remedy was, no presentment by a grand jury, no injured party. All of a sudden we have standing now to challenge the validity of the incarceration. And if the state comes up with something that is valid, that sticks, then we can just accept for value and discharge the debt. And then the debtor is released. The surety is released at the same time. So, if the goal is to get people that are wrongfully incarcerated for victimless crimes out, then the documentation that I know works, that also sets these individuals up to stand as a grantor and a contributing beneficiary to join this force of what we're talking about underneath the authority and the standing of this trust I want to create. Then that documentation would already be done as a consequence of getting them their freedom back.
Okay, well, that's our main mission, is try to get people out. We had just had heard that by doing the county,
that's a double-edged. Yeah, that can be a double-edged sword, because the circumstances and the situations surrounding the incarceration, I think, are important to know. And because I've run into some people that haven't really ever done anything that I could ascertain that involves them deserving to be in jail, but then they get out and they start to learn and implement this stuff, and I see the direction that they're going, and I cut ties, because the standing in honor with clean hands thing is really important for me. And I'm not saying that I'm ready to condemn someone for a mistake they made in the past. That's not my place at all. But I am saying that wise as serpents, harmless as doves includes, in my opinion, an assessment of the commitment that individual is going to have to stand in honor with clean hands moving forward and not let vengeance get a hold of them. And I know that's a tall order, I think, but I do think that it's an important, sorting mechanism, if you will, for individuals to get involved with, at least on the capacity of, the persona, if you will, that I'm trying to embody with this work that I want to do. And the reason why I'm adamant about joining, putting things into the trust indenture, about vengeance not being a part of and not destroying people and not, not countersuing just because you have the ability to, and you end up taking a bunch of value in someone's house and their career and their life. Like, I mean, that is not in the spirit, I believe, of the reason why the divine providence that I believe has happened in my life to grant me this information and this ability and put me in touch with folks like yourself. I think that it's important, and I view it as a trust indenture itself, that I have accepted, the salvation and blood of Christ, and therefore I'm now beholden as a trustee and ambassador of Christ, to hold myself accountable, to the actions that are defined as how I should conduct myself in my private life and in commerce, according to what the Bible says Jesus was trying to do. And so, as long as an individual understands that, is willing to accept that oath and honor, and do I need people to be perfect in that endeavor? Absolutely not. But I need them to know what they're signing up for. I need them to want to try to adhere to that. And so if an individual ends up being incarcerated, usually it ends up being that they don't deserve to be there. But I guess what I'm saying is that, I've seen a few instances where I interact with people after the fact. I'm like, man, you do not have honorable intentions with this information. And it's, and not to say that I think they deserve to be in jail about it, but all the individuals that I have come across, the actions that they've taken afterwards tend to be in line with that vengeful type of a response. And it usually ends up causing a lot more problems in their life. They're fighting a lot more. It's contention for the sake of revenge, and it generally ends up where you have to wield the tools of the enemy, and that gets into you whether you want it to or not. You pick up that weapon of vengeance, and it defines your frame for that action. And so depending on what those individuals want to do, I would be more than happy to try to get them out. But whether or not I think that they might be a candidate to join this, this endeavor, that'll have to be up to them, because the trust indenture, I want it to exemplify the thing that I just described, and, like really stand in honor and hold each other accountable to that, be better than we could be on our own, and really leave vengeance behind, and really focus on the goal, which is restoring the constitutional order to posterity. And so, let's see if we can get him out of jail and see what happens from there. But just know that just because we get him out of jail, I'm not sure I want to work with them, depending on how they conduct themselves afterwards.
That comes to mind, if you got people joining the trust, they be vetted for their proper vetting.
Let's let their actions vet them, and let's build it into the trust indenture that the trust will not act and present their interests if it's deemed by the board that they're acting in a vengeful way.
All right. I'm going to go ahead and proceed to read the scripture on the second film. Okay. Today is December 2nd, so I'll be reading Proverbs 2. My son, do you receive my words, my treasure, and treasure my commands within you, so that you incline your ear to wisdom and apply your heart to understanding. Yes, you cry out for discernment and lift up your voice for understanding. If you seek her as silver and search for her as hidden treasures, then you will understand the fear of the Lord and find the knowledge of God. For the Lord gives wisdom; from his mouth come knowledge and understanding. He stores up sound wisdom for the upright. He is a shield to those who walk uprightly. He guards the paths of justice and preserves the ways of his saint. Then you will understand righteousness and justice, equity, and every good path. When wisdom enters your heart and knowledge is pleasant to your soul, discretion will preserve you. Understanding will keep you, to deliver you from the way of evil, from the man who speaks perverse things, from those who leave the paths of uprightness, to walk in the ways of darkness, who rejoice in doing evil, and delight in the perversity of the wicked, whose ways are crooked and who are devious in their paths, to deliver you from immoral woman, from the seductress who flatters with her words, who forsakes the companion of her youth and forsakes the covenant of her God, For her house leads down to death, and her paths to the dead. None who go to her return, nor do they regain the paths of life. So you may walk in the way of goodness and keep the paths of righteousness. For the upright will dwell in the land, and the blameless will remain in it. But the wicked will be cut off from the earth, and the unfaithful will be uprooted from it. And that concludes today's proverb.
Applicable.
Okay.
Amen.
So, Cody, we look forward to talking to you 2 weeks then. We appreciate everything today. It was very good lessons and good understanding. And thank you for doing it.
Absolutely. It's my pleasure. It's thank you guys for being here. You have no idea the personal satisfaction that I have that I finally found a group of people that, not only can I articulate, the vision that I have on the way out of this nonsense and this mess, but not only are you guys, in agreement, but you get it and you're willing to give it a try. So this is a significant moment in this journey for me. So thank you guys for all being here, and I'm really excited about working on this. It's going to be fantastic.
All right. Thank you. God bless you.
All right, guys.
Talk to you later.
Okay. Until next time.
Thank you. Good call.
Yeah.
Well, 3 minutes to 3, perfect timing.